Mr. Twala's murder and the apparent corroboration that might exist between that and Mr. X's version. How do you say we approach that?
Well, Commissioner, I'd really revert to the first point I make, that if the evidence, if this so-called corroborative evidence standing on its own appears reliable, well, then one can place some reliance on it. But the fact that what Mr. X says is consistent with it is a very weak reed on which to rely, because his evidence may have been tailored for the purpose, and because one just doesn't know what he was told and what he was trying to do. And so once you find that a witness is tailoring his evidence, then the fact that it's consistent with another piece of evidence on a particular issue, I submit, doesn't really take the matter any further. You've got to look at what is the corroborative evidence. Can that carry any weight? So the unfortunate result of this, and I say it is an unfortunate result, and I don't want to be misunderstood in that regard, but the unfortunate result is that the whole of Mr. X's evidence falls to be disregarded, save for the qualification which the Chair has just raised. And that is an unfortunate result, because if the core of his evidence is true, then it's extremely important. But the Commission will never know.
But Lenda, if the whole of his evidence is to be rejected, which other evidence do we have in regard to the Imuti use by the strikers?
Well, there's a range of other pieces of evidence, Commissioner. There is photographic evidence, there's video evidence, there's evidence of police officials, there's the evidence of what was found on the Kopi thereafter, after the events, and there's also, yes, there's Mr. Nzuza's evidence. So there is evidence. I don't think one can, rejection of Mr., or not a rejection, of failure to rely on Mr. X's evidence doesn't lead to the conclusion that Muti, there's no evidence that Muti was used. I think there's overwhelming evidence that Muti was used. And in fact, although there was a sort of a denial initially, in the end it wasn't really denied. The question really is for what purpose was it used?
Yes, well, the other point, of course, is that I understand water being, and herbs being, water being sprayed and herbs being used, but where you have evidence of bodily mutilation of one of the deceased, the absence of evidence explaining that might well, I'm putting this up as a prima facie aspect of the matter to be dealt with, in respect to which we like assistance from Council. But that leads prima facie to the inference that the body was mutilated, body parts were taken for a particular sinister reason. But anyway, that's,
yes.
You didn't mention that. You didn't mention other aspects. That I would have thought prima facie is an important factor on that part of the case.
With respect, yes. Because it's an odd piece of conduct which is unexplained by there's objective evidence of damage to the body, and it's an odd circumstance and no explanation is offered. But as I say, the problem is that if Mr. X was telling the truth, it would have been very important evidence. But the Commission will never know whether it was true. If he was a truthful witness, his reliability has been destroyed by him in the way in which he gave evidence, and unfortunately, one has to say it's been destroyed by whoever it was who assisted him to put together his story in such a manner as to favour the SAPS case. And I have to say that, and say that bluntly. And I'm not accusing, let me say immediately, not accusing our colleagues of that. I want to be quite clear on that.
Mr. Butler, is it the evidence leaders' heads that say that there was in fact no removal of body parts? Did I read it in your head?
There was no removal of the tongue,
yes.
But there was other mutilation of the bodies.
Yes, thank you.
Those are opening submissions, Chair, and Ms. Pillay will now take over and deal with some specific aspects.
Yes, thank you, Mr. Butler. Ms. Pillay?
Thank you, Chair. Chair, the sequence in which I intend to deal with the topics which have been allocated to me will be essentially the sequence we adopt in our heads of argument. I'll begin by setting out some brief comments on the background, and I emphasize brief comments. We will not be repeating what we deal with in our heads of argument. Secondly, I'll deal with the incidents of the 9th and 10th. And the only particular incidents which we'll pay attention to will be the shooting by Lonmin Security on the 10th of August. The next topic will be the 11th of August and the march to the NUM office. The fourth topic will be the 12th of August and the attacks on the Lonmin Security, and the events of the evening of the 12th of August and the killing of Mr. Mabebe. I'll next turn to the question of the 13th of August, dealing first with the early morning killing of Mr. Lange, and then with the failed SABC operation in the afternoon of the 13th. And we'll then look at the 14th of August, and specifically at the killing of Mr. Twala on the 14th of August, and finally deal very briefly with the recommendations that we make which are relevant to these incidents. If we can then begin by looking at the background, and I really intend to highlight three specific issues which we believe are central features of the background to the events of 9 to 16 August. And they fall under three headings, and the first is labor relations at Lonmin, the second is the Impala experience, and the third is the Tlabani experience. In respect of the labor relations at Lonmin, we just want to highlight that in our assessment, the issues really begin in May 2011, and the decision by NUM in May 2011 to dissolve the career branch and to suspend the late Mrs. Steve Kululukile and Daniel Mongwaketsi, that we deal with in paragraphs 35 to 36 of our heads of argument. And of significance is the ensuing unprotected strike, and the decision, importantly, by Lonmin to dismiss 11,000 employees as a result of that strike. Crucially, Chair, and we want to emphasize this, there was a decision by Lonmin subsequently to re-employ, not to reinstate, but to re-employ 9,000 workers, 9,000 of the dismissed workers. The implication of the decision to re-employ was that the workers had to decide afresh which union they chose to belong to. And the result of that was a hotly contested turf war between the two unions which, at that stage, AMCU had taken root at Lonmin. And so you see the events of May 2011 as being the start of this hotly contested rivalry between NUM and AMCU, which featured prominently in the subsequent events of August 2012. The second factual feature which we wanted to highlight, Chair, is the internal process Lonmin was undergoing at the time, which they refer to as their scenario planning process. The process is dealt with in presentations made to Lonmin's EXCO at a few of its EXCO meetings, and seem to have focused on changing trade union dynamics at Lonmin and its implications for Lonmin in terms of its interactions with its workforce. Now, the key factors to emerge from Lonmin's internal scenario planning process we submit are relevant. And the first is Lonmin's recognition that NUM seemed to have lost touch with its members and seems to have lost the confidence of its members. The second is that the current thresholds, the collective bargaining system that Lonmin had in place, and the legal relationships it had built based on these thresholds seem to no longer be valid. The third is that the organizational systems which they employed may be outdated, and Lonmin was engaging with the question of whether a total overhaul was necessary. Now, we say, Chair, that the importance of the scenario planning process is the following. The first is that it was happening exactly at the relevant time, which led to the issues which this Commission is looking at in August 2012. We know that the scenario planning process took root in April 2012 and carried on over a period of time at least until August 2012. And clearly, Chair, the second crucial importance of the scenario planning process was that the RDO demand, which we know became very central to the events that this Commission is dealing with, the RDO demand was discussed within the context of scenario planning. In other words, it formed very much part of Lonmin's internal debate on what the appropriate response was to the RDO demand. And within that background, Chair, the next feature, factual feature, which we seek to highlight in relation to the background issues is the RDO demand itself. We know that the first well-attended RDO meeting, there was evidence by Mr. Da Costa that there had been previous murmurs amongst RDOs about dissatisfaction with their wages, but that the first well-attended meeting was on 21 June 2012. And that seems to be the date on which things really begin to gain momentum. Importantly, at that stage, on 21 June 2012, there was no apparent trade union involvement in the calling of that first, in the calling of that first meeting. After the RDO meeting of 21 June 2012, the workers marched to Mr. Da Costa's office, and we know that he met with 2 delegates of the workers. They presented their demand to him of 12,500, and Mr. Da Costa's response was to tell them that there was organized collective bargaining structures and that wage increases were negotiated centrally through fixed structures and through fixed intervals. Now, that position we describe as the default position. I think Lonmin itself, during evidence, has accepted that as the default position. The workers' immediate response to Mr. Da Costa was that they did not want trade unions involved, and that they were clear about. And Mr. Da Costa then undertook to take the workers' demands to the executive and to revert with a response. Now, we know, Chair, that subsequent to that meeting, Mr. Da Costa addressed a memorandum to the executive, and we deal with this in paragraph 67 and 68 of our heads of argument. The memorandum is important because Mr. Da Costa not only articulates the RDO demand, but also draws to EXCO's attention that the default position may not resolve the issue. He's well aware the Lonmin would elect to opt for the default position, but he specifically informs EXCO that it is unlikely to resolve the issue. Those were his words. He instead, Chair, proposes that Lonmin negotiates nationally, and that's the important part, nationally, with both AMCU and NUM in order to try and find a resolution to the issue. Now, we know that the evidence is, Chair, that that was never done, that that proposal by Mr. Da Costa was not taken up by EXCO. Instead, Chair, what we see in the next few executive committee meetings, Lonmin executive committee meetings during June and July 2012, is that EXCO seemed to be grappling on what was the appropriate response to the RDO demand. Importantly, we see no reflection in any of the minutes that this commission has been furnished with that EXCO took a firm decision that it was not going to engage with the RDO demand, and that it insisted that any demand for wage increase be channeled through the organized bargaining structures. Now, what we do see is that EXCO, in fact, seems to be considering the RDO demand. It seems to be considering opting out of the established bargaining structures, and it seems to want advice on what the correct response is, and in fact asked Mr. Barnard Mokoena to prepare a memorandum to advise EXCO on whether it was permissible or even appropriate to deal with RDO demand outside of the organizational structures. What we do ultimately know is that on the 30th of July 2012, EXCO decides to grant what they call an RDO allowance. In other words, not an increase, as we would ordinarily understand it, but an allowance that would be given to RDOs of 750 Rand per month. And the reasoning seems to be, Chairperson, based on an appreciation that the RDOs at Lonmin were being underpaid when compared to their competitors, specifically Impala and Amplatz. And for that reason, EXCO grants the RDO allowance, not increase but allowance, and that decision is then communicated back to the workers, to the RDOs on the 30th of July. Now, we make the argument, Chair, at page 649 and 650 of our heads of argument, paragraphs 1206 to 1209, that we urge the Commission to find that in all material respects, the system which I've just described, the process which I've just described, resembled a negotiation process, notwithstanding Lonmin's decision to label the ultimate remuneration increase or the ultimate allowance that they've granted as an allowance and not an increase. And the argument is based, Chair, on what we say is the reasonable perception of the workers. They came to Mr. Da Costa with a demand. He took the demand, explicitly told them that he would take it to EXCO and come back with a decision. he comes back with a decision that ultimately results in more money in the hands of the RDOs. We submit that the only reasonable inference or perception that could have been held by the workers in those situations is that they were engaged in a negotiation.
It seems the perception appears to be shared by other people in London as well, from the documentary evidence.
The Career Obi book.
The Currents book and so on.
That's correct, Chair. In fact, London's position at the Commission was that firstly there was no evidence to support a finding that such a perception exists. Now, we draw attention, Chair, to the Career Obi entries which the chairperson has indicated, and we deal with that in paragraph 1209 of our heads of argument. But we also draw attention to the statement of Mr. Sipiwe Boy, and we've referenced that in our heads of argument. And Mr. Boy expressly says that in their view what was happening was a negotiation. And we submit that the collective impact of the RDO, the Career RDO, OB, and Mr. Boy's statement must be sufficient to sustain a finding that there was a perception amongst the workers that what was transpiring was in fact a negotiation.
Sorry, Mr. Blake. Are you saying that there was in fact a negotiation, or it is just a perception on the part of the strikers?
Chair, we're saying
So
that the finding
on what
should
basis can we find that there was in fact a negotiation?
No, Chair, we're saying that we ask for a finding that there was a reasonable perception amongst the workers that the process they were engaging in was a negotiation.
Just to find, not that it was negotiation properly so called, but that it was something which the workers, and not only the workers, but the person responsible for that entry in the OB, which we don't have to go further, discuss further, perceived it as being a form of negotiation. And we can't say that they were unreasonable in so seeing it. That's your submission.
That is
Whether
our
it was negotiation properly so called is a matter of interest to labour lawyers, but not to the Commission. That's your point.
That is our submission, Chair. The next background issue, Chair, which we just want to very briefly deal with, is the experience of Impala. Now, we highlight the Impala experience, Chair, for three reasons. And the first is to emphasize the handling of the RDO demand at Impala, which is described in the scenario planning process as the Impala contagion, and what the implication of the way in which Impala granted or dealt with its RDO demand meant that the RDOs at Korea may take it upon themselves to demand an increase from Lonmin. And that's, I think, a useful way of describing it is the Impala contagion. The second implication of the Impala experience, Chair, is that the increase meant that the RDOs at Lonmin operations were being paid significantly less than what we say is the market rate at that stage because of the experience of Impala and Amplats. The third significance of the Impala experience, Chair, is the violence and unrest that accompanied the strike at Impala closely resembled what was happening at Lonmin at the time. Now, we've dealt with this point in our heads of argument, and the only reason we highlight it, Chair, is in response to one of the key contentions advanced by SABC, and that's that the events at Marikana, the unrest at Marikana was unprecedented, and therefore called for an unprecedented response. Now, we highlight the Impala experience purely to show that the experiences were substantially similar, and therefore SABC cannot claim before this Commission that it was dealing with an unprecedented event.
And you rely for that on the evidence that there were 6 deaths and a number of attacks on people going to work and intimidation.
That's correct, Commissioner Emraj.
Remind me, was there an unprotected strike at Impala at the time?
There was, Chair.
And so what we saw at Lonmin was an unprotected strike, an attempt made to enforce it by violence and intimidation. So anyone who looked at the Impala experience would have been able to predict with a fair degree of accuracy that what was going to happen at Lonmin was the same. Is that your submission?
It is, Chair, and bearing in mind specifically the nature of the public protests that accompanied the Impala strike, we say that there's a substantial similarity between that and what ultimately transpired at Lonmin. We make the same point, Chair, and this is on the question of whether or not the events at Marikana were unprecedented. We make the same point in relation to the Tlabani incident, which we deal with at paragraph 89 of our heads of argument. You had, for example, in that case, a protest of 15,000 people armed with sticks and pangas and who were clearly showing a propensity for violence and, in fact, attacked the police. And again, the Klabani incident demonstrates that the events at Marikana were not unprecedented. We also highlight the Klabani experience, Chair, to show the involvement of the TRT and the use of the R5s in Klabani. And specifically, Chair, you'll recall that this led to Colonel Vermaak addressing a letter to the National Commissioner, which is Exhibit JJ137, highlighting the difficulties with using sharp-point ammunition in the course of public order operations. So that, in a very brief...
This part, the lack of precedent, or the alleged lack of precedent, is answered on two levels. Firstly, the nature of the trouble, if one can call it that, at Lonmin, attempt to enforce an unprotected strike by murder and mayhem. That was something that had happened before at Impala. There was precedent for that. And secondly, a very serious public order incident where the police had to use, first had to involve the TRT and had to use sharp ammunition. There was also precedent for that. That was the Shabani incident. So it's on those two levels you say that the allegation that this was unprecedented is not well-founded.
That is our submission. That is our submission, Chair.
Where do we find the evidence about the details of the violence at Impala apart from the occurrence book entries?
I think, Commissioner Hemraj, it's reflected in Exhibit L, and we have referenced that.
Oh, I see. Yes, thank you.
Sorry, the narrative as well as the narrative to Exhibit L. I think it's Exhibit Triple H. I think it's 38, if I'm not mistaken.
But no statements or...
No, there are no
other
statements.
Evidence besides that. Yes, thank you.
It does seem, though, to be common cause. It was mentioned in evidence. And as the authorities say, a commission is entitled to have regard to evidential material of a much wider nature than a court hearing a civil or criminal dispute would be entitled to.
And it does come from one of SABC's own documents, which is the Marikana narrative.
Sorry, was the Muti involved in that incident of the Impala?
Commissioner Dakota, I'm actually unable to answer the question. May I look into it and revert to you with an answer on that? So, in summary, Chair, those are the facts which we sought to draw your attention to, just to set the scene, the background scene to what eventually transpired at Marikana. If I can then turn to the events themselves, and beginning with the events of the 9th to 10th of August, we've dealt with the demand which emanated on the 9th of August in our heads of argument, and on the 10th of August we all know that there was a march to Lonmin's LPD, and we say that the objective evidence showed that the march eventually was dispersed peacefully, and this is consistent with the testimony of Captain Govender. We've referred in our heads of argument to the objective evidence. That's the videos taken by Warrant Officer Masinia, Mr. Kali Miles, and Mr. P.W. Buotha. What we do want to deal with very briefly, Chair, is the shooting incidents by Lonmin Security on the evening of the 10th of August. Now, at paragraph 194 of our heads of argument, we identify the three shooting incidents by Lonmin Security on the 10th of August. They occurred at 1835, 1859, and 2010. And we have shooting incident reports for these three incidents. And all of the shooting incidents reports indicate that the shooting was done, and I must emphasize the shooting by rubber bullets. The shooting was done in the presence of SAPS. Now, we know that Captain Govender was on the scene at least from shortly before 1830. He says that he left before the 2010 shooting. And his testimony before the Commission was that he saw no reason for SAPS to take action. And we submit, Chair, that in the absence of concrete evidence from Lonmin of the nature of what they claim was intimidatory conduct by the people gathered on the 10th, and in view of Captain Govender's testimony that in fact there was no basis for SAPS to take action, we submit that this commission should make a finding that, in fact, the shooting incidents of 1835, 1859, and 2010 on the 11th was unjustified. Now,
Presumably the excision of the note of the entries about it in the London occurrence book is evidential material from which inferences may also be drawn.
that's correct, Chair, together with the shooting incident reports. If I can just deal quickly with the insertions in the OB book, the Lonman Career OB book. This is one of those instances where you will recall, Chairperson, that Mr. Sinclair testified that these insertions were deleted in the version of the Career OB book that was eventually submitted to the Commission. And we submit, Chair, and we've made the point in our heads of argument that the Commission can draw an inference from this fact. If the shooting was fully justified, the question that arises is why Lonman would feel the need to delete these insertions from the OB book.
It might be that while Captain Govender was there, that the strikers desisted from their any threatening behaviour, because otherwise it's just a shooting by Lonman Security for absolutely no reason, if everyone's standing there peacefully doing nothing.
Well, the evidence of Captain Govender is that that's exactly what happened, Commissioner Himraj. The question mark relates to the third of the three shootings, and that's the shooting at 2010, where Captain Govender was not present at the 2010 shooting. And we know that there's other reports, which Captain Govender refers to in one of his earlier emails, which say that there was intimidatory action at 2010, or at around 2000 hours. So the submissions that we make at best for Lonman means that there is absolutely no basis for the finding that there was justifiable basis for Lonman to shoot at 1835 and 1859. If there are allegations of assaults by people, it only relates to 2000 hours, when Captain Govender was not there, and where there is a third report made to Captain Govender that there were assaults taking place at 2000 hours. And you'll see that in Lonman's replying affidavit, they take issue with Captain Govender's testimony, and they contend he was unable to explain why people were just standing around with knopkieries in their possessions. But we do know that those they had earlier when they marched to LPD office in any event. And so we say that there's no inference to be drawn that they had these in their possession at 1800 hours. And they also say that his account of events is inconsistent with the reports made to him. But I've already made the point that the reports made to him only relate to the 2000 hours shooting, and not to the two earlier reported shootings.
Sorry, other than the evidence of Govender and Lonmin, do we have any other evidence to the effect that people were just standing there and doing nothing wrong and so on, and then Lonmin security just shot at them with the rubber bullets?
We don't have any evidence from people who were actually gathered there, Commissioner Dakota, and that's part of the difficulty that we have. But in the same token, we don't have evidence that, in fact, there were assaults at 1835 and 1859. Absolutely no evidence.
And also that there were no assaults from the people who were there.
That is what I'm saying, yes.
There are statements from those two persons who were in fact shot by Lonman Security.
That's right, Commissioner Himraj. There's statements by Mr. Mutingwani and Mr. Dlomo, and we've got their medical records that show that they were ultimately shot by Lonman. But again, no evidence from Lonman that would justify their need to use rubber bullets at that time. If I can then briefly deal with the contingency plan of the 10th of August. We've dealt with the fact that the contingency plan was in place on the 10th of August. That's according to the evidence of Colonel Marafe. And we've set out here in paragraph 214 of our heads of argument, we've set out our criticism of the contingency plan. And just to sum it all up, there are essentially three criticisms against the 10th of August contingency plan. The first is that the plan was vague and lacked detail. The second is that the plan was in fact never implemented. Captain Govender didn't even know of the existence of the plan. And the third is that the contingency plan was never adapted in light of the intelligence reports, which we'll deal with shortly, in light of the intelligence reports of pending threats, violence and intimidation. There was absolutely no attempt to adapt the contingency plan so it could be a proper response to the
main
situation.
problem was it wasn't implemented. One wonders if it wasn't just a paper exercise, just to have a piece of paper to show that something was being looked at or considered. If you have a contingency plan dealing with the kind of problems that were being experienced, you'd expect some attempt to be made to implement it. I mean, even Captain Govender says that he was listed in the plan as being someone playing an important role. He wasn't even told about it. And that's something I find difficult to understand.
That is
Unless the contingency plan was just a piece of paper to put in a file if anyone asked the question, well, we had a plan.
that is one of our criticisms of the plan, Chair.
And one of the main aspects of the plan was the visible policing. And that's why it's even more odd that Captain Govender didn't know about it.
That is so, Commissioner Hemraj. And in fact, we'll highlight as we go through each of the events that there seemed to be a complete lack of visible policing during this key period before the 16th of August. Chair, the one overarching theme which we deal with in our heads of argument in relation to the events of the 10th, 11th, 12th and 13th of August is Lonmin's failure to apply its own procedures for dealing with industrial action. Now, we know that the document in question is Exhibit XXX, which is Lonmin's Counter-Industrial Action Response Procedure, which essentially, Chair, if you look at the content of that document, for all intents and purposes, it mirrors our understanding of public order prescripts. In other words, that there has to be proper intelligence gathering, there has to be effective and detailed planning, there has to be proper briefing, and there has to be proper debriefing, and proper records kept of all meetings involving these prescripts which I've just set out. Now, both Mr. Sinclair and Mr. Blow testified that they considered that the document bound Lonmin Security. And they both testified that the operational procedures, Lonmin Security operational procedures, were based on this document. Now, we see very belatedly in the evidence of Mr. Mokoena and in the heads of argument as well as the replying heads of argument by Lonmin, a contention that that document was never formally accepted by EXCO and therefore doesn't bind Lonmin. Now, we submit, Chair, that the question of whether or not the document was formally adopted by EXCO is not really a relevant one. Ultimately, the question was, in terms of what document was Lonmin Security arranging their operations? And on the evidence of both Mr. Sinclair and Mr. Blow, it was Exhibit XXX8. So we would submit...
Who drew it up? Was it Blow or Bottas?
It was Mr. Blow that actually drew it up.
Blow drew it up. So Blow presumably didn't think it was not binding. It's certainly not binding on him and his colleagues. So the question is, why didn't he imply it? It may be correct that EXCO never gave it its nihil obstat and imprimatur and so forth, but as far as they were concerned, Blow and his colleagues, it was the procedure that was applied, or to be applied.
That is our submission, Chair. And in fact, the document does reflect in a footer to the document that there is a signed version of it available and that it's being stored in archives. So we would submit that within that evidence, against that totality of evidence, the Commission should find that, in fact, the document does bind Lonmin Security and that they do arrange their operations.
Whether it binds them or not is possibly a technical point. The question is, it was accepted by them as being the appropriate procedure to follow. Whether it was technically binding, it may be an interesting question that I don't propose wasting time on. But if they regard it as the appropriate procedure to follow, why didn't they follow it? But linked to that is a problem I've got put to Mr. Sinclair. And I said, when you come back, when you resume your evidence, you can deal with it. And that was the suggestion that there was a concealment of what happened on the 10th. One of the witnesses actually transferred the events of the 10th to the 11th in a way which there was a fair degree of circumstantial evidence indicating it did happen on the 11th. In fact, it was conceded it hadn't. It was a lapse of memory. He could singularly unconvincing. I put to him, it was prima facie evidence that incorrect information was being put before us. And he said I said he would have an opportunity to deal with when you come back, and he didn't. So is there any value that one must attach to that evidence?
Chair, we submit that there is, and we will make submissions later on, Chair, on there was another crucial aspect on which Mr. Sinclair was given an opportunity to go away and to come back with documents, and that's around his risk assessment, the double rate risk assessment, and whether in fact he informed his contractors about this increased risk. And he was invited, even though he was under cross-examination, he was invited to go back and to produce documents which showed that in fact that was conveyed to the contractors, and in fact he didn't. So we would submit that on both scores, that this commission should draw an inference against Lonman. Against the backdrop of XXX, Chair, we make submissions on the 11th of August and the march to the NUM offices, which we deal with in paragraph 221 and onwards of our heads of argument. What is not in dispute in relation to the march, Chair, is that the strikers had taken a decision to march to the NUM offices. And we know that very early on there was evidence that in fact they were planning to march past the NUM offices, but I think that was put to bed by the evidence of Mr. Mabuya Kulu. We can now accept that they were marching to the NUM offices. The second fact is that the NUM officers were warned by Lonman Security that the strikers intended to march to their offices and intended to burn it down. The third fact is that the strikers, there were about 3,000 of them that marched the NUM offices. And fourthly, that...
Yes, give me your factors, and then I want to ask you a question. Carry on.
Fourthly, that the NUM members, having heard the warning by Lonman Security, went outside their offices and lined up outside their offices. And we know that they then chased the strikers, and that's the finding which we asked the Commission to make. The first action was actually by the NUM members, and shot at them. And we know that two strikers, Mr. Mabuya Kulu and Mr. Ngema, were shot as a result of that.
Now I'll ask you my question. Do we have clear evidence as to the time when that incident took place? One of the heads that I read, I think it was the Human Rights Commission, but I may be wrong, so I don't want to make allegation against them if it's not correct. One of the heads I read said it happened at 11 o'clock. Is there any evidence from which we can determine with more accuracy than that when precisely that incident happened?
Chair, can I revert to you on the question of, I think it's an interesting issue that we need to address. Can I revert to you on the exact time, according to the evidence?
And there's a further fact that I want to put to you at this stage, which may have a bearing on the motives of the strikers in going to the NUM office. And that was that the evidence seems to indicate that NUM were not only opposed to the strike, but they were actually taking positive steps to undermine the strike by conveying some of the workers to the shafts. I'm not sure whether they actually gave them protection, but they certainly took positive steps to undermine the strike on the night of the 10th, 11th. And the point is made in the argument somewhere that this is something that the strikers didn't like, and it would be relevant as to a reason why they went to the NUM offices and what they were about. But the reason I asked you the time is I think the arms merchant in Marikana started selling his machetes and other implements of war around about 9 o'clock in the morning. It's important to know when the incident happened, because a number of things follow from that. But I don't know whether you were able to deal with that now. I was proposing to take the adjournment roundabout now. In fact, I was going to ask you, when we reach a suitable stage for the adjournment, would you let me know?
Chair, I think it is a suitable stage now.
But before we do that, Advocate Hemraj wants to ask you a question.
Have we been told, Ms. Pillay, from where the information emanated that the strikers intended to burn the NUM office? Where
Commissioner Hemraj, the informant, the Lonman informant, told Mr. Dibakwani and Mr. About that he was present at the meeting and that a decision had been taken to burn the NUM offices. We also know that one of the NUM members had received a telephone call from, Mr. Kolkati, who had received a telephone call from an unknown person. He declined to indicate who that person was. who says that he was present in the RDO meeting and that a decision had been taken to burn the NUM offices.
So both anonymous sources.
Well, I think there is evidence before the Commission to indicate who the Lonman undercover agent was, but in relation to the latter one, there isn't. Yes.
Yes, thank you. Thank you.
Now, I think we must try to make a resolution and keep to it, that the whole of this oral address section of the Commission sitting, we take quarter of an hour for tea, and no time longer. Otherwise, we're going to get all sorts of complaints from people whose argument or highlighting time has been eaten into, drunk into by tea drinkers. So 15 minutes strictly. Commission resumes. I don't know whether we quite made it within 15 minutes, but I think I'm told it's 14. Well, I thank you for the extra minute. I hope you'll use it with profit, Ms. Pillay.
I'll try to, Chair. Chair, just to answer the question around timing. At paragraph 2 to 4 of our heads, we indicate that Mr. Mabuya Kolu says that the crowd met at Wonderkop and exchanged views at 9 o'clock in the morning. So the meeting started at 9. We know that, and we deal with this at paragraph 235, Mr. Kasim says that at 9 o'clock he had a rush of people buying pangas at his shop. And at paragraph 226, we indicate that Mr. Matogelwa, the London security guard, says that at about 11 o'clock the group started marching. He says they started marching at 11. That's the best evidence that we have at the moment.
Okay, thank you. That's the answer to my question. Thank you.
Essentially, Chair, the two issues which we submit needs to be decided in relation to the events of the 11th is whether the strikers had violent intent and whether...
Beg your pardon, before you carry on, I've been asked by Mr. Budlander to announce, which I am prepared to do, that we're going to take a half-hour lunch break today because we lost time in starting because of the problem with the aeroplanes yesterday from Durban Airport. So we'll adjourn at 1 and we'll resume at 1:30. Sorry, Ms. Pillay, I should have mentioned that before you started.
Thank you, Chair. The two issues, very briefly, Chair, is whether the strikers had violent intent and whether NUM was justified in shooting at the strikers. In relation to the former question, Chair, we submit that the evidence is not conclusive, but there are a number of factors that suggest that the strikers had violent intent. And we refer briefly to these as follows. Firstly, the evidence of Mr. Mutlugelwa and Mr. Dibakwani. Mr. Mutlugelwa testified, but in relation to Mr. Dibakwani, we rely on his statement, that they were informed by the informant who was present at the meeting of the RDOs that they indicated that they were going to the NUM offices to burn the offices down. We also refer to Mr. Seteleli's statement, which is Exhibit YY1, paragraph 17, where he indicates that the strikers were armed with knop kieries and spears. We refer to the evidence of Mr. Gegeleza, who indicates that Mr. Kolkati told him that he was informed that by someone who, other than the London informant, we suppose, who was in the meeting, who indicated that the RDOs intended to march to the NUM offices to burn it down. We refer to Mr. Kasim's testimony about the rush to buy pangas. And finally, we refer, Chair, to Mr. Mabuya Kolu's explanation that the strikers wanted to talk to NUM, and that was the purpose of the strike. Now, we submit that this... the purposes of the march, not the strike, the march. And we submit that his explanation is wholly implausible. The strikers were openly antagonistic to NUM. By that time, we'd already seen reports of intimidation against people wanting to go to work. They were well aware that NUM was opposed to the strike and was actively taking steps to ensure people get to work. And in those circumstances, we submit the strikers would have had no reason to talk to NUM, as Mr. Mabuya Kolu suggests that they intended to. In any case, Chair...
Would be prepared to talk to them at the point of an assegai or a panga.
That is so, Chair.
Which,
in any event, Chair, the objective evidence is that 3,000 strikers marched to NUM, and we submit the only inference, you cannot draw an inference that 3,000 people marched to the NUM offices with spears and knop kieries to talk to the people at NUM. So, given that the strikers were armed, given that they were marching en masse to the NUM offices, we submit that it can reasonably be found that they posed a significant threat to the people at the NUM offices. And we submit that in those circumstances, it was reasonable for the people in the NUM office to perceive that they were under attack by the strikers. Firstly, they were expressly informed of that by London Security. Secondly, they had information from the RDO meeting that that's the intention of the RDOs. Thirdly, the sheer number of the strikers. And fourthly, by then there was already reports of widespread intimidation by the strikers. And so we conclude, Chair, that on the probabilities, what ultimately happened is that it was a preemptive strike by the NUM members in order to defend themselves and to defend their office.
shouldn't they have fired warning shots before shooting at people?
Well, we know that they did not fire warning
Yes.
shots.
So, if we also know that when shots were fired, certainly when people were hit, the brave strikers turned around and ran the other direction. Now, if warning shots had been fired, and it was clear to them that their opponents were armed and were prepared to use firearms, then the injuries to the two people who were injured might not have taken place. Well, that's correct, isn't it?
Chair, at this stage, I think it's speculative that the warning shots would have yielded those results.
Well,
because we know that
well,
what actually...
It's speculative, we don't know, but they might have. But the people who fired shots and injured people without giving a warning, in circumstances where I think they were some distance away when the shots were fired, if warning shots could have been fired, isn't there a prima facie case of attempted murder against the people who fired those shots?
Purely on the basis that they didn't fire warning shots?
Yes. Well, if they fired the shots, they fired it in defense, in self-defense, or perhaps punitive defense, or whatever one wants to say. There was, apart from the fact there wasn't an imminent threat at that stage, because it's not suggested any of the strikers had firearms, and they were quite a distance away. Apart from that, one of the principles applicable in the case of self-defense is that if you can, you should give your person who you think is going to attack you warning that if he continues, he or she continues, this might be sexist, he or she is going to continue with his conduct, that you will have to take serious action to ward off what he's doing. So prima facie, again, I think everyone's agreed that as far as recommending prosecutions are concerned, not recommending prosecution, recommending to the DPP that consideration be given to the institution of a prosecution, possibly to further investigation, there should be, as it were, a prima facie case. Now, is there not a prima facie case against the two people who, I don't know if it was two or one, but two shots were fired. Is there not a prima facie case of attempted murder in respect of those two shots that were fired by one or more NUM members on the morning of the 11th of August?
Chair, we won't be averse to a recommendation that be investigated. I think the whole notion of whether warning shots would have had the same result that the actual shots did was not canvassed on the evidence. But we wouldn't be averse to that recommendation.
In a case where self-defense is being interrogated, it's not normally a relevant factor to whether a warning would have necessarily have been effective. One of the things that someone invoking the doctrine of self-defense is obliged to comply with. That is so, isn't it?
That firstly, the threat was imminent, and secondly, that there was proportionality. Yes, Chair.
They did have the opportunity to leave the premises. They didn't have to stay there. They didn't have to arm themselves with firearms, and they didn't have to wait for the crowd to arrive. So that must go towards that intention as well, mustn't it?
It should, Commissioner Hemraj, but the other side of the coin is whether they're obliged to do that. In instance,
the fact that's relevant there is whether they were entitled to defend the office. And I'm not sure there's evidence on it, but there may be. But that the probabilities are in any event that all their records would be in the office, a significant number of their records anyway. And it would be quite a serious problem for NUM if the offices were burned down and their records were destroyed. So one of the factors one's got to consider is whether they would have been entitled to have stayed there, not run away. Normally, if you can run away, you must run away. But if you are staying to defend your records and your office, that may be something which is relevant. But anyway, we don't have to go there. If we were to send the case to the DPP, that's a matter which would presumably be the subject of the investigation.
That is so, Chair, and the reasonableness of the judgment call, because the evidence is that the NUM members exercised a judgment call about what was the best way to defend themselves, and this was what they ultimately decided to do. Apart from the conduct of the NUM members, Chair, the two issues which we seek to highlight is the conduct of Lonman Security, firstly, and the conduct of SABC, which we believe also needs to be investigated. Lonman Security on the day was wholly inadequate.
There's some evidence that the evidence is a bit equivocal on the matter. I thought suspiciously so. There's some evidential material to indicate that not only did the NUM people fire shots, there's a suggestion on the papers that the Lonman security did so as well. That may or may not be true, but there's certainly a strong indication that that is so. And if that's so, of course, then there was another curtain that is drawn across that. So we do know, because they admitted, that what one can call NUM shots were fired. And there was a docket opened, and there was some cross-examination by Mr. Mpofu, I think it was, about how not much progress was made in investigating the cases in the docket. But that we'd have to send off to the DPP for consideration and so forth, and further investigation. But there's also, is there not, an aspect of possible shots fired by the Lonman security people, before we get to the point you could deal with, the inadequacy of Lonman security. But
yes,
that is a point also, is it not?
That's reflected in quadruple E 19.1, Chair. That's the OB book, that it does have reports of shooting by Lonman security on the date. And it's one of those entries that were deleted by Mr. Sinclair subsequently. But apart from that entry, there's absolutely no evidence of exactly what transpired. So it's a factor which the Commission should take into account.
Sorry, I suppose the property belongs to Lonmin. There was information that it was going to be burnt. Wouldn't you think that it would be the duty of the Lonmin security to protect the property of Lonmin?
Again, Commissioner Dakota,
as it was with the NUM officials to protect their property inside the West.
The difficulty, Commissioner Dakota, is we've got absolutely no evidence around the circumstances in which those shots were fired. So we're unable to say if it was before the march, during the march, in the chaos that ensued afterwards. We just don't know.
So where would it take us then to consider that evidence then?
Well, the evidence is there. It's objective evidence in the career OB book, and I'm not sure how you take that forward.
I'm thinking aloud now. It's prima facie view, obviously. But if everything had been above board and the Lonman security officials had fired, as the OB book says they did, and had fired in circumstances that were perfectly justifiable, one would have expected the entry to remain in the occurrence book. The very fact it was removed is already an indication that something unsatisfactory happened, which caused an over-vigilant Lonman official to cause that entry to be deleted.
Chair, we submit that inference is open to the Commission to draw. And then to highlight the last aspect, Chair, in relation to the events of the 11th, and that's the conduct of SABC. Because what you see is a complete absence of visible policing on the 11th. Now, we'll deal shortly, Chair, in relation to the events of the 13th, about the crime intelligence reports available at the time, according to the version of Brigadier Engelbrecht, and the fact that he conveyed that to Major General Mpembe, and notwithstanding that there was inadequate visible policing in place during this critical period. And we submit that the absence of SAP's presence on the 11th is again a demonstration of a complete absence of visible policing. It might also be one of the factors which unfortunately led to NUM taking the stance that it did, because there was firstly inadequate Lonman security and secondly an absence of SAP's presence on the day.
Are you saying, do you submit that visible policing would have been able to deal with the threat that the strikers were said to be posing to the NUM office?
Well, we submit, Commissioner Hemraj, that would have been their role, one way or the other. That's exactly the policing role which they meant to play.
Didn't Captain Govender said that his was not the role of public order policing as Vispal? I think that was his evidence, wasn't it?
It was, but if we look at the crime intelligence report and we look at what Brigadier Engelbrecht expected when he forwarded that to Major General Mpembe at that stage, it was only that there be heightened visible policing and not necessarily POP operations.
At least if they were there, they might have then arranged for further resources to be available.
That is so, Commissioner.
There's another factor, I take it, because Mpembe was also across that apparently that the visible policing he thought was going to be put in place wasn't. And that is, visible policing may deter people from misbehaving. It's one thing to say the visible policing would have been able to drive back a group of strikers who were going to the NUM office to burn it down. But the very fact that there was visible policing there might have made the leaders of the strikers, for all one knows, made them think again, and decided it may not be a smart idea to go to the NUM offices because the full force of the law will be brought to bear against them. So the purpose of visible policing, as I understand, is not to necessarily deter, not necessarily arrest criminals and so on, but to deter them from becoming criminal or engaging in criminal activities. Isn't that so?
That is our submission, Chair. If I can then turn Chair, to the events of the 12th of August. We deal in our heads of arguments with the attacks on Mr. Lowe and Mr. Forster at paragraphs 270 and 271. And if we can then turn to the killing of Mr. Fundi and Mabelani. We know, Chair, that the strikers have accepted responsibility for the killing of Mr. Fundi and Mabelani. They've put forward no basis of justification. And we submit that in the circumstances, the Commission must find that the killings were unlawful. The controversial issue in relation to the deaths of Mr. Mabelani and Mr. Fundi is the extent to which Lonmin should be held responsible for failing to take adequate steps to properly protect and or secure its employees. Now, you will know, Chairperson, that the ICAM report identified certain shortcomings in Lonmin's approach, and this we deal with in paragraph 285 of our heads of arguments. We just want to highlight two of the issues that have been raised in the ICAM report. And the first is on the question of intelligence gathering. Now, we show, in fact, Chair, in our heads of argument in paragraph 287, that Lonmin actually had intelligence available to it. It had an informant that conveyed to Lonmin that the strikers had undergone rituals and were, in the words of the informant, preparing for war. So Lonmin was aware, in our submission, Chair, based on the intelligence available, of the risk posed by the strikers. And notwithstanding this, what we fail to see, Chair, in the evidence before the Commission is any concrete steps taken by Lonmin to protect against the risk posed by the strikers. Importantly, we don't see in its planning of its security operations that it considered this risk and factored this into what XXX expected of it. In other words, proper risk assessment, proper planning, and proper briefing. Now, we deal with, in our heads of argument, with the evidence of Firstly, Chair, we know that there was no planning involved. There was no evidence before Lonmin that there was either a contingency or some sort of operational plan in place. We know Mr. Mutluchelwa's evidence that there was absolutely no briefing of the security guards for them to understand what it is they were faced with and what they were expected to do. We deal with, in our heads of argument, with the question of the armored vehicles, Chair. And the point which seems to be lost and which Lonmin doesn't really respond to is that in the correspondence which it's clear that Lonmin Security identified a real risk to its security members, and it prescribed a solution. And the solution that Lonmin Security themselves prescribe is the need for armored vehicles. They indicate the heightened risk faced by its security members, that crowds are becoming more violent and more prone to attack, and therefore one of the best ways to protect their members is by means of armored vehicles. And notwithstanding this clearly foreseen risk, we see a policy decision by Lonmin firstly to demilitarize, and secondly not to acquire or procure armored vehicles. Instead, Lonmin preferred to rely on the vehicles of contractors. And we know, Chair, that on the evidence, the contractors' vehicles were themselves in questionable condition. We know that Protea Coin Security had 2 armored vehicles at its disposal, the one caught on fire en route to Moenoi, and the second one, on the evidence of Mr. Boertes, it struggled to start or to move on the 11th. So clearly, we submit, Chair, that in relation to the question of armored vehicles, Lonmin has to accept responsibility for, firstly, its decision not to acquire armored vehicles of its own when it was clear that there was a very real risk posed to its employees. And secondly, where it depended on a contractor's armored vehicles for failing to ensure that those armored vehicles were in proper working condition.
Part of that is a question of delay. If you haven't got armored vehicles on the premises, you have to contact the contractors and say, please bring your armored vehicle. You would contact them at the first sign of trouble, I presume. By the time the armored vehicles get there, the trouble may have happened. So it's not a very satisfactory thing to say, well, never mind, we've got contractors who will bring armored vehicles onto the premises as and when they need it. The question, its importance would be, even if they all have been adequately maintained and are all able to get there as soon as they're sent for, there's still the distinct risk that they'll get there too late. Isn't that so?
We submit that that is the case, Chair.
Whether Lonman was aware that there were defects with the two armoured vehicles that Protea Kind Security provided, and whether they in fact had any control over that.
Commissioner Himraj, there's no evidence that they were aware beforehand, and in fact the fact that Mr. Bottas jumped into the armoured vehicle on the 11th seems to indicate that they didn't know that there were problems with the armoured vehicle. That doesn't detract, we submit, from the principle that they ought to know aware if they're relying on these armoured vehicles to protect their employees. So in other words, they have to have some sort of mechanism in place to ensure that these armoured vehicles are in proper working condition when they need them.
Isn't that possibly being a little bit harsh? You've got a contractor whose job it is to have armed vehicles available. There's a problem with a particular armed vehicle on a particular day. You then say to them, look here, there's a problem. It could have been very serious. Fortunately, it wasn't. But please, you must ensure that in future that doesn't happen. Can they be expected, once you accept, which you may not accept, but once you accept that the decision to rely on outsourced armoured vehicles provided by a contractor as and when needed, if you accept that that's a permissible approach, then the fact that one or other of them may have broken down occasionally doesn't necessarily mean that you must then abandon the idea of having a contractor and purchase your own armoured vehicle. Surely the first thing to do would be to contact the contractor and say, look here, this kind of thing mustn't happen again, otherwise we'll have to cancel your contract and do something else. But can one go beyond that?
Well, Chairperson, the issue really is that we do not see any form of protocol where Lonman holds its contractors accountable for the vehicles that it relies on, and that's really the heart of the complaint. If we can then turn to the killing of Mr. Mabebe on the evening of the 12th of August. Again, Chairperson, the strikers have accepted responsibility for the killing of Mr. Mabebe. They've not put forward any grounds for justification, and in circumstances we submit that the Commission must find that the killing was unlawful. The secondary question that arises is Lonman's responsibility for failing to adequately protect both K4 Shaft and Mr. Mabebe. We've set out in our heads of argument at paragraph 320 that there was intelligence available of direct threats made to K4 Shaft and to the workers who were based at K4 Shaft. We've put forward the argument that at the time Lonman was actively encouraging workers to come to work, notwithstanding these clear threats that were made, and that clearly Lonman failed to take adequate steps to protect K4, notwithstanding the clear risk that they faced. We know that at the time, on Mr. Sinclair's evidence, the risk assessment conducted by Lonman Security was a double red, which was probably of the highest level, and notwithstanding this excessive or this extreme risk assessment, there was no evidence that it was conveyed to contractors, together with an instruction to contractors that security should be heightened in view of the heightened risk. And I've already mentioned, Chairperson, that Mr. Sinclair was given an opportunity, notwithstanding the fact that he was under cross-examination, to try and get the information to show that, in fact, there was this instruction given to contractors of the need for heightened security at K4. He failed to take the invitation up, and we submit that in the circumstances, this Commission should draw a negative inference from that fact. And indeed, Chair, there is no evidence of increased security at K4. Quite the contrary. The evidence is that the security at K4 was wholly lacking. And in the circumstances, we submit that Lonman should be held responsible for the attack on Mr. Mabebe and the attack on Mr. Van Vieren, which we've dealt with already. In relation to the 13th of August, they are
Responsible for failing to take precautions to prevent
to protect its,
the
to,
attacks.
to protect its employees and that of contractors on site. In relation to the events of the 13th, Chair, there are two incidents which we need to briefly deal with. The first is the killing of Mr. Lange in the early hours of the 13th, and the second is the SABC operation on the 13th. In relation to the killing of Mr. Lange, we know that the evidence is that Mr. Lange was killed on a popular route for workers who walked from their hostels to EPL, where they caught a bus to Safi Shaft. The strikers have taken responsibility for Mr. Lange's death. Again, they've put up no basis for justification, and we submit it's open for the Commission to make a finding that the killing was unlawful. The secondary question, again, Chair, is around Lonman's responsibility for Mr. Lange's death. We draw attention in our heads of argument at paragraph 334 to Mr. Jamison's email to the DG of the DMR, where he says that the situation is neither stable nor under control, and where he says to the DG that Lonman do not have the capacity to protect life and limb. We also draw attention, Chair, to the evidence of Mr. Sinclair, who testified or conceded in cross-examination that there were serious capacity constraints that faced Lonman's security, and that they simply did not have the capacity to protect all of the workers who were coming to work. Mr. Mokoena testified, and the reference is in our heads of argument, that it was irresponsible for Lonman to ask someone like Mr. Lange to come to work when they were aware that they were not able to adequately protect him. Now, in those circumstances, Chair, we submit that it's open for the Commission to make a finding that it was irresponsible for Lonman to call on people like Mr. Lange to come to work and then fail to adequately protect them, and it was a dereliction of their duty to protect their workers. We've dealt in our heads of argument with the question of Lonman, of the evidence that Lonman considered closing the mine, Chair, and that it seemed to have taken a business decision not to do so. But I'll deal more fully with this issue when I deal with recommendations at the end of my address. Again, just to highlight, Chair, on the 13th of August, particularly around the time when Mr. Lange was killed, we again see an absence of visible policing, notwithstanding intelligence reports of violence and intimidation, and also the brutal killing of Mr. Fundi and Mabelani the day before, notwithstanding the serious violence that plagued Marikana at the time. There was an absolute absence of visible policing in place. Then to turn very briefly to the SABC, not briefly, isn't it?
The contingency plan of the 10th was still in place, and that called for visible policing, and absolutely nothing was done to implement it.
That is so, Chair. Absolutely nothing was done. And then to turn to the big event of the 13th, and that's the SABC operation. We deal in paragraph 339, Chair, with the prelude to the operation. And the whole issue turns on the nature of crime intelligence available and what was done on the basis of that crime intelligence. And we've set out what Brigadier Engelbrecht's version of events is, which is at odds with Major General Mpembe's version. And we say that Brigadier Engelbrecht's version should be favored, and it should be found that he indeed conveyed the extent of the crime intelligence reports that he received. He did convey to Major General Mpembe, who ought to have been aware by the time he received those reports of the serious nature of the violence that was plaguing Marikana at the time. And we show in our heads of argument, Chair, that Major General Mpembe's evidence is in itself inconsistent. There seems to be, on his part, a deliberate attempt to downplay the extent of his knowledge prior to him arriving at Marikana on the 13th. And we say that this, we draw two inferences from this, from his deliberate attempt to do that. And we've shown in our heads of argument the difficulties we have with his testimony. And it seems to be because, firstly, it would mean he's responsible for the lack of visible policing in the area. Because the question needs to be asked, if he was aware of these crime intelligence reports in the full extent that Brigadier Engelbrecht seems to have conveyed them, why didn't he act concretely to ensure that visible policing was in place?
He was on leave, of course, wasn't he? But the evidence is that on the Sunday, when he received the report, he then whom did he contact? Was it Naidu?
That's correct, Chair. But we submit that his obligation goes beyond that. Even though he's on leave, when he receives a report...
I'm sorry, but if he's on leave, and I think the Provincial Commissioner was on leave as well, the acting Provincial Commissioner was General Naidu. Now, is it obligatory for a senior officer who's on leave to do any more than to convey the information he's received to the person who is performing the function of Provincial Commissioner at that time? Is that not enough?
It goes beyond that, Chair, because he seems to have given Brigadier Engelbrecht some sort of assurance that visible policing will be put in place. But we don't see any concrete steps taken by him, either an instruction to Brigadier Carlitz or to whoever else was in charge at the time.
No, but if he's on leave, he gets this information, visible policing is needed. He says to Engelbrecht, I agree with you, visible policing is needed, it will be provided. He then phones the person who's not on leave, who's actually operationally responsible at the time, and says, this is the information. Clearly we need some visible policing. Presumably the person to whom he speaks agrees, and that's it. Is he obliged to do any more than that? Unless he has reason to believe, perhaps, that nothing was happening. Then he must follow it up. What the follow-up procedures would involve is, of course, another matter. But is one not putting too heavy a burden on him in the light of the fact that he was on leave, in light of the fact he did see to it that the information was conveyed to the person who was responsible for carrying it out at the time?
Furthermore, was it really put to him that he had that burden, notwithstanding that he was on leave, to do more than that, so that he could get the advantage of his explanation?
Commissioner Chakota, he was cross-examined to a limited extent on this issue. I think the difficulties that we faced is that the fuller statement from Brigadier Engelbrecht only became available much later, so that we understood much later the extent of the information which he had passed on to General Mpembe at the time. And the question mark...
What I want to know is whether he was cross-examined as to why he didn't do anything further than conducting the, for example, the supply of the visible policing, notwithstanding that he's on leave and things like that.
My recollection, Commissioner Dakota, is that he was cross-examined on this question of what he did when he received the information. And short of saying that he just passed the information on to General Naidu, he couldn't give an explanation of any further concrete steps that he did in light of the seriousness of the intelligence that he received.
Did he have to do any more? If he's on leave, he gets serious information, he passes it on to the responsible senior officer, the acting provincial commissioner at the time, I think. Acting provincial commissioner. Acting provincial, isn't he entitled to say, well, I must assume that my colleague who's acting provincial commissioner will do the necessary? It's not for me to sit on his shoulder and make sure that he's doing his job, is it? Unless, of course, there's possibly reason to think that something untoward was happening or something that should have been happening wasn't happening. Isn't that fair?
Chair, there's a question mark around whether he conveyed the full extent of the crime intelligence reports on, and that's the first issue, is the extent of the information that he conveyed, which Brigadier Engelbrecht had conveyed to him. Because you'll recall that he actually initially denied having received those full reports from Brigadier Engelbrecht, and that was part of the problem. And specifically around the incidents of the 12th and the serious violence that had taken place on the 12th. Brigadier Engelbrecht's version is that after those incidents, he again informed General Mpembe of the seriousness of the violence that had taken place. And General Mpembe's initial version before the commission was that he hadn't received those reports.
What does General Naidu, who was the acting provincial commissioner on that day, what did he say about it?
General Naidu's evidence, Chair, was that he hadn't received the reports around the 12th from General Mpembe. And that's the issue.
Why would intelligence be communicated to a deputy provincial commissioner who's on leave and then not communicated to the acting provincial commissioner? Surely that would have gone the route of being communicated officially to the person holding the position and on duty at the time.
Commissioner Hemraj, I think it stems from the fact that General Mpembe gave Brigadier Engelbrecht the assurance that they would act on the information that he gave. So it was because Brigadier Engelbrecht never testified, it's never been, we've never gone into why he kept on sending the reports to General Mpembe instead of the operational commander at Marikana at the time. But it would seem from the evidence that that's based on the feedback given by General Mpembe. We almost seem to have given assurance that visible policing would be put in place.
Was it explored with General Naidu whether those reports ever came to his attention from Brigadier Engelbrecht? Because I don't recall that.
Can't answer it. We'll obviously have to investigate.
We can revert on that particular question. But
yes.
the role of the General Naidu claims that he didn't get the SMS from General Mpembe.
My question was whether General Naidu was privy to the information that emanated from Brigadier Engelbrecht directly from the intelligence branch.
My understanding is there is no evidence that
Was
happened.
that raised with the General Naidu, whether he got that information at all from intelligence?
Good. Ms. Pillay, we've asked the question. You don't have to give us the answer now. You can give us this later.
We'll revert on that
The question is
particular
on the
question.
table, as it were,
Yes.
and I hope it will be answered before the end of the 14th.
We'll revert on that question, Chair. The other important aspect, Chair, of the extent of the crime intelligence reports available to General Mpembe revolves around his decision on the 13th, when he gets to Marikana, to deal with the breakaway march as a spontaneous gathering. And we've made that point in our heads of argument, and I'll turn to it now. So we know that when the provincial commissioner, she issues an instruction that the crowd should be attended, the breakaway group that they see on the CCTV monitor should be attended to. She makes an entry in the OB book. Importantly, Chair, is Major General Mpembe's testimony that it was his duty to operationalize that instruction. And it is how he goes about doing that, how he operationalizes the PC's instruction, that we take issue with. Now, we say that in view of the crime intelligence reports that he had available to him, he was well aware that the breakaway group was part of the big group that had assembled on the copy. We know that Brigadier Khaleds told him that, because that was the information that the Lonman jock was facing at the time. We therefore say, Chair, that his explanation that this was a spontaneous event is not convincing. Even if it was a spontaneous event, we say that that doesn't exclude the application of ordinary public order policing prescripts. So in other words, the fact that it's a spontaneous event doesn't mean that there is no obligation to conduct some sort of threat assessment, some sort of plan, put some sort of plan in place, particularly having regard to what it is that you plan to do at the spontaneous event. Now, we know that General Mpembe went with the intention of disarming and dispersing the strikers. Now, we submit that with that intention in mind, he ought to have conducted a proper threat assessment, put in place a proper plan, and briefed his members accordingly. And his failure to do that, we submit, is highly questionable.
Did he really have time for that? There's a spontaneous group. He's told, and there were a series of killings prior to that. Did he really have time to make a proper planning for that?
Commissioner Tekota,
Shouldn't he have, would you fault him the manner in which he dealt with the group at the time when he confronted them, applying, as he says, the situational appropriateness or whatever?
Commissioner Tekota, two issues. And the first is, I think we must be clear on when General Mpembe relies on the doctrine of situational appropriateness. And he only invokes that doctrine at the point where he takes the decision to allow the strikers to proceed to the copy and to accompany them. So it is at that point that he invokes the doctrine of situational appropriateness. At a much earlier stage, His explanation is that he adopts the approach that he does because he sees it as a spontaneous gathering. Now, we've already said that in view of the crime intelligence reports available to him, it was not open for him to view this as a spontaneous gathering, firstly. Secondly, that SABC have not put forward any facts to justify their a decision to act there and then. And that's an answer to your question. Because what we do know, Commissioner Tukota, is that these strikers, the breakaway group, at that stage were on their way to march to K3 Shaft. We know that they were stopped en route by Lonman Security, who actually told them that they should not proceed to K3 Shaft and that they should go back to where they came from. And we know that the strikers then peacefully turn around, and we've got evidence of that, and then march back to the copy. And that's the point at which they were intercepted by General Mpembe. So we submit, bearing in mind those facts, there was absolutely no compelling reason for SABC to take action there and then.
Was he aware of all of that?
This was...
That is now the security people are preventing them, and then was he aware of that?
Well, the point, Commissioner Tukota, is all of this gets monitored by Lonman Security. And this is exactly the point at which SABC see the group on the CCTV monitor. So if, at the very least, he ought to have tried to understand exactly where this group is coming from and where they were going to, before then going to this railway line to try and intercept them. That is our submission. In any event, we submit that that information must have been freely available because Lonman Security was closely monitoring this group, and they were then in the Lonman Jock when this group was seen on the Lonman CCTV.
Ms. Pillay, I'm not entirely clear about the suggestion that it's not spontaneous. How much notice would they have had? When would they have seen the group, the breakaway group, marching? How much time would he have had to know that they had broken away and they were going in a particular direction?
What we know, Commissioner Hemraj, is that Lonman Security is closely monitoring the group. They know the group breaks away. They know the group is en route to K3. They intercept the group, and they make them turn around and march back. That much we know.
And what is their time frame?
I'm not
That's really
sure
the question, because when do they know? How do they determine spontaneity? When does the group start marching? Is it 1 hour? Is it 2 hours? Is it half an hour? It's not very clear to me. And that's why I don't understand the criticism around spontaneous.
The criticism, Commissioner Hemraj, goes beyond attaching an hour or a minute time frame to what exactly transpired. The criticism is that the breakaway group was part of a bigger issue, which SABC was well aware of. Firstly, because they knew that the people had been gathering on the copy. And secondly, that's exactly what their crime intelligence reports were saying to them. And they were aware of the strikers' propensity for violence because that's exactly what had transpired immediately before the breakaway group had left the copy. So that's the first point. The second point is that Lonman Security was closely monitoring the situation. That much we know. And that at that stage, SABC see the breakaway group on the monitor in Lonman Jock. So at the very least, they had the information readily available as to exactly where the group was coming from and where the group was going to.
I understand your submission as regards the gathering at the copy. I do follow that. I'm just not sure whether General Mpembe would have had sufficient notice about the march, the breakaway group leaving the copy and marching. I'm not sure about the time frame there. So, or whether they would have anticipated that, in fact, the breakaway group from the copy would then march, or when it is that Lonman communicated it to them and how much time they had to then deal with it. That's not clear to me.
We know that from the time that the OB entry is made, there's not a big lapse of time to when General Mpembe actually finds himself out on the railway line. I think we've dealt with that time on the evidence. I think it's about 45 minutes.
No, I don't understand the significance of this distinction between a breakaway group and a spontaneous group. It seems to me that whether or not they were a breakaway group doesn't help us very much. It clearly was some kind of spontaneous march by a portion of those on the copy. So there was an element of spontaneity there. They knew that they were a dangerous lot because presumably they knew about the weapons. They could see those on the screen and so on. So what he knew was that here was a group of dangerous people. Whether he actually focused on the fact they'd come from the copy doesn't seem to be terribly relevant. Whether they had or they hadn't, it was a spontaneous march, or relatively spontaneous march, without any warning at all, to K3, turned round by the security people on their way back now to the place from which they came. They were a dangerous lot because they were marching around with dangerous weapons. You're not allowed to do that. That's illegal. So that had to be stopped. So I don't understand where this argument is getting us. I can understand the argument that maybe he should have done a bit more to prepare his troops, if one can call them that, to deal with the situation. But then there's the factor which my colleague Advocate de Corte has mentioned. How much time did he have? One's got to answer those questions before one can start criticizing him. He's got a potentially dangerous situation, over 200 people marching around with dangerous weapons. All right, they've been turned back from the initial destination. What exactly they're going to do on their way back home is an unknown. What must he do? He can't send them a message and say, would you please postpone your march for 2 hours to give me a chance to have a conference with my people and work out a plan. He's got to deal with it pretty smartly, hasn't he? So how much time did he have? One mustn't set impossible standards for people, because apart from the fact they're not going to comply with them, they're going to have a contempt for any attempt to set any standard. So the question one's got to ask oneself, surely, is how much time did he have? And once you answer that one, then you've got to ask the next question, what was it reasonable to expect him to do in the time that he had? And if the answer is he had 3 minutes, he didn't have time to do anything, well then you can't criticize him for not doing anything. Isn't that so?
The issue, Chair, is really around what did he do? What did he decide to do, given those facts that you've just outlined? And that is the nub of the criticism. Because what he decided to do was actually a very drastic measure. He decided to go out and to disperse and to disarm those strikers. And that is really the point of criticism. Was even assuming that it was a spontaneous event, there were other avenues open to him to dealing with that spontaneous gathering, rather than take the drastic decision to disarm and disperse the strikers forcibly.
I'm not sure with respect that you're putting it entirely correctly. The order that he disarm and disperse came from the provincial commissioner. One may wish to criticize her for giving an order like that at that time. That was the order he had to comply with. He doesn't appear actually to set about doing it. What he did was, as far as I can read the evidence, what he did was he went to them and he would try by the power of persuasion to get them to lay down their arms. And if he could do it by persuasion, well then there wouldn't be a problem. If he wasn't able to persuade them, he then made a decision, which was, I think, an appropriate decision, situationally appropriate decision, not to try to disarm them, because he realized the consequences, but rather to escort them home to the Kopi and take it further from there. We know things went wrong thereafter, and one of the points we're going to have to debate in a moment is why. But can one really fault him? He's got an instruction, which in prima facie was an ill-advised and hasty instruction at the time, which he's supposed to comply with. He goes there, he tries to implement it by oratory. He doesn't succeed. He says, right, well, I can't now disperse them and disarm them because there's going to be bloodshed. The sensible thing to do is to escort them home. Now, if that's all that he did, can one really criticize him?
Chair, with respect, the difficulty is that that's not all that he did. Because what the chairperson has left out is the crucial conduct where he issues an ultimatum and he starts counting. And that, we submit, is consistent with his predetermined approach that he wanted to either through persuasion or other means get the strikers to disperse and disarm.
When that was clearly not going to work, when they got up at the count of 3, he then did not do it. He allowed them to go. He made no attempt to disarm them, no attempt to disperse them. He actually had a brief discussion with the 2IC, Colonel Marafi. They had a debate, which he made a decision, which I think he would contend was an appropriate decision in the circumstances. And if it had stopped there wouldn't have been any trouble. Isn't that right? As far as we know.
In fact, he had already decided that he was going to allow them, because there was no time for him after the count to go and discuss with them. Not so. He had phoned the provincial commission that I can't do it, I've got to allow them.
And then he started counting, which is the inexplicable part of all of this. But the difficulty, Chair, that
was the last attempt for him. He had already made up his mind.
That was partly oratory.
Why should you fault him for that?
We don't fault General Mpembe on his decision to apply the doctrine of situational appropriateness at that point. The problem we have is twofold. Firstly, that the members were not properly briefed on exactly what was expected of them once the strikers were allowed to move through. And the second then relates to his whole notion that the strikers pose a danger to the informal settlements. And that, we submit, is a factor he took into account without any evidence to warrant such an approach. And it goes back to the notion of exactly how much he knew about the strikers before he decided to do what he did.
According to him, he told Marafi what his decision was. Marafi accepted it. And according to the evidence, as far as he was concerned, that instruction was sent down the line to the ordinary foot soldiers. That's all he had to do. The instructions were to do nothing, just escort them. You don't have to have a briefing lasting half an hour to tell people to do that. And he gave that instruction. He says, and it's not disputed, I think, that was conveyed, at least as far as he was concerned, he had reason to believe it was conveyed. And if it stayed there, and they'd done that, there wouldn't be the problem. What he also did was, there was a fear that they might go into the informal settlements, and they might attack people who weren't taking part in the strike, because there's a history of that. That's why Lange died, for example. So what he did was also sensible. He sent the Inyalas along the road to guard the informal settlements, to stop them from going there, to deviating. I know we've got other problems with what happened thereafter, and that's the trickier part of the argument. But up to this point, the point we're busy with now, I must tell you that prima facie, I don't see that he has a problem in the answer. But we have heard your arguments, and I don't want to stop you unduly, but I think we probably debated the matter as appropriately as we can in the situation in which we find ourselves.
In a final attempt to persuade you, Chair, if I may just point to the testimony of Colonel Marafi, which we submit is crucial, because this is an experienced POP commander. He says that had he known what was conveyed to General Mpembe, in other words, the crime intelligence reports, he would have ensured that they had a proper operational plan in place in order to deal with the strikers.
Did he explain how many minutes he would have had to put that proper operational plan in place, regard being had to the instructions which Mpembe got from the Provincial Commissioner?
Now, if you look at the instruction...
lex non cogit ad impossibilia presumably applies even in the field of police operation.
But Chair, if you look at that instruction, General Mbombo says that the planning has been adjusted in order to operationalize that instruction, and we know that's never happened. And that was incumbent on the operational commander to make sure that that happens. There's a second problem, which is highlighted by Colonel Marafi, and that is in a POP operation of that nature, when you do take action, you need to inform the strikers of what you intend doing so that they understand the ambits of acceptable conduct for them. And that wasn't done by General Mpembe. So we would submit, therefore, that on those two legs that his conduct is highly questionable.
Advocate Hemraj asked me a question which I'm afraid I'm going to have to ask you because I don't know the answer. She says, is it clear what aspect of Mpembe's conduct you were criticizing? Precisely what action? If we were going to draw a charge sheet against him for some disciplinary hearing, or what exactly would we say in the charge sheet?
that he failed to ensure that a proper plan was in place to deal with the strikers, particularly in light of the crime intelligence reports available. That he didn't adequately brief his members on what to expect, that's the important part, because they were dealing with a group of people that had a propensity for violence. That they didn't know what was expected of them when they went out to the railway line. And that, in fact, when he did decide to adopt the principle of situational appropriateness, which we don't take issue with, that at that stage there was not a proper briefing to members, because if you look at the statements of members, there's clearly a confusion around what was expected of them.
His answer to that is that he told Marafi understood. Marafi then sent the message down the line. He had no reason to believe that it hadn't been sent down the line or hadn't been understood. It was a complicated thing. And now we could be talking about what happened on the 16th, then you can understand it. But it's simple. Escort them, don't interfere with them, escort them back to the Kopi. That's it. How long do you have to instruct people on that?
Except, Chair, that it was more complicated than that, because they included in that instruction was that they shouldn't be allowed to go near the informal settlements. Now,
there are 2 points about it. Firstly, he dealt with that by sending them nyalas along the road to shield the informal settlement. That's the first point. And secondly, you argue that there's no evidence to suggest that they did go towards the informal settlement. So they, after all, had come from the Kopi. They were going back to the Kopi. Just in case they decided to go into the informal settlement and get up to mischief, he put the Inyalas there. So I suppose theoretically he could have said, make sure they don't go into the informal settlement. But in fact, there's no causal connection between his failure to say that and what happened. Because according to your argument, they didn't go to the informal settlement. And the trouble didn't arise because of the fact that they were going to the informal settlement and his members weren't instructed as to what to do in that situation. So it's an argument in the air, isn't it? Not connected to the actual facts.
Well, the fact, Chairperson, is that Warrant Officer Kuhn discharged the tear gas on the strength.
That's the next point you've got to get.
Yeah.
If you are correct in saying that he changed his mind and he gave the instruction to discharge the tear gas, and whether he gave the instruction to fire the stun grenades or not, but assuming he did that as well, then obviously there's serious grounds for criticizing him. The factual question we have to wrestle with is whether he gave that instruction. You submit that he did.
We do. Can I pull together the evidence just very briefly, because I really am running out of time. And this are the
Just
factors.
before you get there, I still don't understand why you criticize him for having failed to brief the members, in view of the fact that immediately after they refused, then they were escorted. Where would they have got that information from if they were not briefed? They then lined up the Nyalas against the settlement. Where would they have got that information if they were not briefed?
Well, they say that they weren't adequately briefed, and that's the problem. Commissioner Tukwasa.
How would they have done that? Because immediately he said, I'm disarming you. He explained to them the purpose of the police presence. They refused. He had already told them he must escort them. Then they did that. They were going. They lined up the Nyalas. Now, how would they have got that information if they were not briefed?
It's exactly the nature of the information that was given to members, which is what we're taking issue with. Because they immediately lined up behind the strikers. Whether they were able to do that or whether they should have done that in view of the crime intelligence reports of how violent these people were, that's one of the issues that we're dealing with.
Isn't the confusion, sorry to interrupt you, but isn't the confusion among the members about whether they were to disarm and disperse, isn't that what the confusion is in the statement from the policemen, not whether they were just to escort them initially? Isn't that where the difficulty arises?
Indeed, Commissioner Himraj, it's that level of briefing, the initial decision to disarm and disperse, but also in relation to monitoring and following the strikers. The issue around briefing is that they ought to have been informed how dangerous the strikers really are. And that we don't see evidence of. So what we do see General Mpembe is doing is getting a line of policemen immediately behind the strikers in situations where they actually are known to be a very violent bunch of people. The factors, Chairperson, that we say support the finding that there was an instruction are the following.
I'm so sorry, I just...
Whose finding is that?
A finding by the Commission that support a finding by the Commission that there was an instruction.
You say we should make it.
That's correct, yes. The factors are the following. The first is the version of Warrant Officer Kuhn, which we dealt with in our heads of argument. We point out that Warrant Officer Kuhn's version that he received an instruction and
Somebody doesn't know.
And then asked, just to clarify, and then asked if he should fire the tear gas, and then gets the answer that he should.
From someone else, he doesn't know.
It's consistent, Chair, with Captain Tupe's version that General Mpembe issued the instruction that Warrant Officer Kuhn asked for clarity on whether he should, and that General Mpembe confirmed.
But Kuhn didn't know who confirmed.
No. He says that...
Obvious, Mpembe's gave the order. The other one is, did he give it over the radio? Was it in order to fire tear gas or use stun grenades as well? We've got statements of people who say, allegedly relatively contemporaneous statements, that he said, fire tear gas and stun grenades. That's not what Kim said. Was it over the radio? Remember, the evidence was Kim was the far left, Pembe was the right. The most unlikely person to be told to do that, I would have thought, would have been Kim. How would he have heard it unless the radio was used? And if the radio order had been Kuhn, fire tear gas, I could understand it. But if the order was just fire tear gas, how come Kuhn was the only one who fired tear gas? The whole thing doesn't stand together.
Because he was one of the few that had the tear gas canisters on him.
How many people had tear gas canisters? You know? But Lloyd had decided on his own that he was going to get some stun grenades, and he actually got them from someone else and took them off. One wonders why that was. But
the second factor, Chair, is the failure to institute disciplinary proceedings, and we against Warrant Officer Kuhn, notwithstanding General Mpembe's version that he fired tear gas without an instruction from his operational commander. The third factor is the version of Captain Tupe, which we've already dealt with. The fourth factor is what transpired at Roots, and we submit that there's evidence of what transpired at Roots, firstly in the Marikana narrative, which is H 28, which reflects that an instruction was given by General Mpembe. There's further evidence in Captain Tupe's evidence before the Commission that General Mpembe said at Roots that he could not remember giving the instruction, but that it was possible that he did so. And then there's the independent evidence of Colonel Vermaak to the same effect, that General Mpembe said at Roots that he couldn't remember firing the tear gas, but it was possible that he did. Now, we submit that on that collection of facts, it can sustain a finding that, in fact, General Mpembe did issue the instruction.
But in view of the fact that the other one was on the far left and the other one on the far right, what finding must we make as to by what means would he have done that? And that information will only go to Warrant Officer Kuhn.
Well, we know, Commissioner Dakota, that it wasn't over the radio because...
In the light of the denial by General Mpembe and in the light of the fact that it's not clear from the members who were there as to who actually gave that order.
Except Captain Tupe, and we have yet to hear an explanation for why he would fabricate that evidence.
The main problem I've got, I must tell you, frankly, is I can't understand why Mpembe would have given that instruction. Mpembe had arranged in Yalas to stop people going to the informal settlement. They weren't going to the informal settlement. We know that. At least you would contend with me to find that. Things are going according to the plan that he had. It's called a dynamic plan by Mr. White, but it's a plan anyway. Things are going according to the plan. They're walking quietly. They're not misbehaving. They're being escorted. There's no danger to the informal settlement. Why suddenly would he take it upon himself to give this mad order to somehow to Kuhn at the far left? I got it to Kuhn at the far left. If he didn't use his radio, something I also don't understand. Please, Kuhn, situated as you are on the far left, would you fire a tear gas canister in that direction to stop them veering off to the right to the informal settlement? And Kuhn says, and Kuhn then says, who, me? And he asked someone else, he doesn't know who gave the order. He asked someone else, he doesn't know who that is either. And then he does it. And then Beloy takes it upon himself to use one of the stun grenades that he'd taken from somebody else, not because of any order he'd got from Mpembe by that time. The evidence seems to indicate that there was something in the nature of a mutiny. There was something of a significant disagreement by some of the members there who didn't agree with what Mpembe did. They felt the strong-armed militaristic approach was the answer to the situation, and the result was catastrophe. But one must, in the face of all that conflicting evidence and those probabilities moving in the opposite direction, blame Mpembe for that. There are a lot of other things one can blame Mpembe for. I don't quarrel with that. But this particular one doesn't make sense. I just say that it's my prima facie view. If I'm wrong, I'm happy to be persuaded that is so.
Chairperson, this could take the whole day, and I've got limited time. I think we'll come back and reply and deal with some of the issues that you raise. If I can then turn very quickly to the deaths on the 13th. And the evidence is that the strikers killed Warrant Officer Munene, Warrant Officer Lipaku, and attacked Lieutenant Beloy. There's been no evidence of justification for that conduct, and we submit that the finding should be made
make a finding on
that it was unlawful. In relation to Mr. Marty, we deal with his killing in paragraph 4 to 6 of our heads. We submit that it's probable that Mr. Marty was shot by SABC members. We take note of Mr. Nzuza's testimony that he assisted one of the strikers from the main scene, assisted him out and left him at the door of one of the shacks. We submit that we don't know whether that's Mr. Marty or not, but if it is, then it shows that Mr. Marty was shot at the main scene. If it's not, Chairperson, then the probabilities are that Mr. Marty was shot by Captain Tupe and Sergeant Seholeya, who both, Captain Tupe testified to having shot in that vicinity, where of the shacks where Mr. Marty was eventually found, and both of them.
Prima facie evidence, which justifies referring to the DPP, to the provincial DPP, investigation of the circumstances in which Marty died.
That's right.
Indications are he died because of a shot fired by a policeman.
That's correct.
And further than that, one doesn't have to take it, isn't it?
That's correct, Chair. And the same applies to Mr. Jokanisi. I should indicate that until yesterday, in relation to Mr. Jokanisi, we've been working on the report of Dr. Nkosi. And then yesterday, the family's team produced the report of Dr. Naidu, and I'm not sure if the commissioners have copies of the report, which the families argue indicate that Mr. Jokanisi was incapacitated to the point where we can draw the conclusion that he was shot where he was eventually found.
I would like to take a 5-minute comfort break, only a 5-minute comfort break at this stage, and then you can tell us more about Mr. Jokanisi after that. session resumes. I did notice that there was a fair degree of approval of the fact that we took a 5-minute break. I didn't understand it to be unwelcome to many of the people here. But anyway, let's carry on now. Yes, Ms.
Chair, in relation to Mr. Giaconisi, and I'm actually very reluctant to do it, but we've made copies of the report that was made available yesterday, but unfortunately it came out quite... Let me hand up these copies. Just to contextualize,
one of the things we've got to do with this, presumably we've got to make an exhibit. It's got to be part of the record, right? And presumably it's got to be sent to the original pathologist as well for his comment. But in the meanwhile, if you're going to hand it in, it's got to be an exhibit. So you fortunately were the clerk of the papers and the mistress of the exhibits and all that. So can you please give us the next exhibit number?
Chair, the next exhibit number is quadruple Z 33.
Quadruple Z 33.
Yes. I should add that there are two reports. This is the one in relation to Mr. Giaconisi. There is also an additional report in relation to Mr. Sokanyele. So I'm not sure if
well, I'll tell you what to do. Let's not worry about it for the moment. It's a housekeeping matter we can deal with in due course. There also, I understand, some affidavits that have come to hand from some of the generals who were at the National Management Forum meeting, who were asked on my instructions to indicate what they remember of what was said at that meeting. And those statements will also have to be handed in exhibit. So that's a matter that we can deal with at an appropriate stage. I don't know whether the parties have yet got those affidavits. They're not all in yet. But if they haven't got them, I trust that arrangements will be made for them to see them in due course. But let's carry on with the argument for the moment.
No. We've made the submission, Chair, that the evidence seems to indicate that Mr. Giaconisi was killed in the vicinity of Warrant Officer Lipaku, and we base this on the statement of Warrant Officer Kuhn, who indicates in his statement that he saw one of the strikers, part of the group that was attacking Warrant Officer Lipaku, that he rushed to assist Warrant Officer Lipaku, but by the time he got there, found that the striker had been shot in the shoulder, and he then handcuffed the striker, and there's then the last sentence that in the meantime the striker had died. He later found out that the striker had died. So this is the only evidence we have of facts around the death of a striker at the first scene. When I say the first scene, I mean the main scene of the 13th. So
it's the only evidence we've got at the moment, but I mean, surely it's a matter of common courtesy. Dr. Nkosi should be asked to respond to this. I noticed that Dr. Naidu says on the second page, paragraph 4, dealing with the problem as to whether Mr. Giaconisi was able to walk after the injury, he says, on the assumption that the lumbar spinal cord was damaged significantly, and bearing in mind this was a high-velocity injury, I would expect that he was not able to walk or run. Now, obviously, if the assumption is correct, obviously what he says is correct also. But inasmuch as he complains about the description of the lumbar spinal injury, I must say it would be more helpful to us to hear first what Dr. Nkosi has to say. So I would request that attempt to be made as soon as possible to A, give this document to Dr. Nkosi if he hasn't got it yet, and B, to ask him to comment. Because clearly, if this fact which is set out here is correct, that he wasn't capable of walking, then that would be a very material factor in regard to the submissions that you're going to present to us.
would it not be proper for all the new post-mortem reports or reports that have emanated from Dr. Naidu to be at least sent to Dr. Nkosi or the other pathologists who did the post-mortem just for comment?
Commissioner Himraj, we will attend to that. Actually, I think in those circumstances, it's more appropriate to make complete submissions on the death of Mr. Jokanisi at that time. In relation to Mr. Sokanyile, Chair, we submit that the evidence before the Commission supports a finding that Mr. Sokanyile was shot by SABC. There's no basis for justification put up by SABC for killing Mr. Sokanyile, even on the statements of Sergeant Sekholeya and Constable Mgui.
There are 2 points on there. The one is based on the general approach to the issues that arise in this case relating to deaths. The Human Rights Commission have referred to Mabasa versus Felix, which certainly is authority that in a delictual claim, the person responsible for a death bears an onus to justify the killing. And the general submissions made in relation to the duty of commissions in dealing with cases of killings is in line with Mabasa's case. So the first point is, can it be said that the police that are liable, as it were, for the death, unless they can prove justification, establish facts which give rise? The answer to that appears to be yes. The narrower question, or in some ways the more significant one, is, are we able to say that who was responsible for firing the shots, and if so, then can we say there was prima facie criminal conduct which would cause us to send the case off to the provincial DPP for further investigation? One of the problems we've got is, because R5s were used, bullets disintegrated, there's no meaningful ballistic evidence, which in itself I would have thought is, apart from all the other reasons, is a good reason not to use R5s in future. But is the evidence sufficiently detailed to enable us to identify, I think the correct word is shooter. We were using shotist, which I think is more expression for use for Bisley competitions than activities of the kind we've been busy with in this commission. So I think shooter is the right word, because I think Mr. Budlander used earlier. Can we identify, on the balance of probabilities perhaps, the shooter who was responsible for Mr. Jokanisi's death? Your point is it's unexplained, so therefore Mabasa and Felix would kick in. And in any civil case, the police would have difficulties in showing justification for the killing. But, of course, if it were a criminal case, the onus would be the other way around. And we would have to, those responsible for the prosecution would have to show who shot and in what circumstances. Now, that's the point you're dealing with nowadays.
That's correct, Chair. And we say in our heads of argument that we've identified the potential shooters/killers, but that this merits further investigation. And finally, Chair, just to deal with the death of Mr. Twala on the 14th, which we deal with in paragraph 553 to 558 of our heads of argument. And we say that the strikers have accepted responsibility for the death of Mr. Twala, notwithstanding the evidence of Mr. X, and we've dealt already with the veracity of his evidence. There's no evidence to tie the killing of Mr. Twala to a particular individual striker, and that similarly is a death that warrants further investigation.
I don't remember the details of what was in the docket. You remember that in some of the dockets relating to the killings, there was statements, and we were told that there would be vigorous contentions that they were inadmissible because they'd been obtained voluntarily from the witness. And of course, and we have kept away from that for reasons which I take it everyone understands. But of course, if there is that evidence in dockets, that's something which the DPP will consider, and he will consider whether the statements, whether he'll be able to show, if he is minded to prosecute somebody, that these statements are admissible. But that's a matter, that's something we mercifully are not obliged to consider. That's right, isn't it?
That's our submission, Chair. In relation to the question of recommendations, Chair, we've dealt with it in our heads of argument, and in the interest of time, it's something which we can deal with in reply, with your leave.
Thank you. Who's next?
I am, Chair. Chairperson, Commissioners, I'm responsible for 5 broad topics in my section of the oral submissions. That's the Phase 2 submissions, the events of 16 August, Roots and the evidence leaders' general criticism of SABC's response to the shootings and the Commission, the miscellaneous issues that you find at pages 597 to 624 of our heads, and the responsibility of SABC for the events of the 16th and the punitive recommendations relating to the 16th. Now, it's not remotely possible to address all of these topics in the 90 minutes that I have. So, for the most part, I will merely stand by the written submissions of the evidence leaders.
The idea that I explained from the beginning, the argument is the written argument. The oral hearing is for points to be highlighted, questions asked by the commissioners to be answered, and so forth, and presumably any extra responses to points made by some.
I'll obviously
and
be.
Your heads have clearly been written on the assumption that is to be the approach. That's why the heads are as full and as comprehensive as they are.
Thank you, Chair. So I'm going to be focusing on issues where the heads need amplification or clarification, and in some cases, reconsideration. And topics which we consider particularly important. But there is always a risk that that selection of topics might miss topics which you, Chair and Commissioners, regard as important and which you would like to canvass. And so I would invite you, if I gloss past a topic where you have particular concerns, to put the question to me. If I can answer it on my feet, I will do so. If I can't, we will get you a written
on your feet,
answer.
because you seem to be on something else at the moment. We won't go there either.
Indeed, Chair. But before I get to the heads, there is an issue that I need to address up front, because it's an issue that's particularly important in relation to the 16th, and that is the effect of these 2 years of Commission hearings on our capacity to be numbed to events that were truly horrifying. For 2 years, we've been staring minutely at what is the single most disturbing episode in the history of our democracy. And we've been looking day in and day out at images of bodies being shot to pieces by military assault rifles. It's only natural that we've developed coping mechanisms to deal with this process. But part of what those coping mechanisms do is that they normalize the horrific, and they dull our outrage at what should be and what is truly unacceptable. In a constitutional democracy, it is never acceptable for a line of police members armed with military assault rifles to fire 300 shots into a crowd of striking minors. That is never acceptable in a constitutional democracy. In a constitutional democracy, it is never acceptable for the police to fire blindly into a kopje so that they kill 15 people in circumstances where they can't even describe the circumstances of the death, never mind justify them. Now, our learned friends from SABC have done an excellent job in trying to normalize this conduct on the part of their clients. And they've been helped by the numbness that we've all developed by being forced to focus on this unimaginable horror day in and day out. But when it comes to making your findings and writing your report, Mr. Chairperson, you and your commissioners need at some level to think yourselves back to that night of Thursday, the 16th of August, when you switched on television and you saw the Reuters footage which was broadcast. The Reuters footage that we now know so well and that we've analyzed frame by frame. You need to remember the horror that you experienced when you saw it for the first time. When you saw miners being gunned down by the TRT line, because that horror reflects the reality of the situation. And that's a reality that's at real risk of being diluted through these proceedings, because one cannot stare at horror every day for 2 years without normalizing it. And I would urge you to do that, because if you cannot rediscover the horror that you experienced before your responses to the killings were numbed by daily exposure, there will be two unfortunate consequences for this commission. The first is your report will be compromised, because it will be shaped by the numbing effect of overexposure to horror. And the second is that your report will lack legitimacy, because the South African public, which has not been numbed to the horror of what took place, that hasn't been here day in and day out, will not accept a report that fails to regard the killings at Marikana with the horror that they merit. So I would strongly emphasize that you try to take yourselves back to the first time that you saw what we now have seen day in and day out on the Reuters footage, on the ETV footage. And the way to try to rediscover some of that horror is to stop thinking of the striking miners as an undifferentiated, faceless mob. Start thinking of individuals. Start thinking of Mr. Gwelani, who was walking back to Nkaneng more than 250 meters away from the TRT line, was shot through the head by an R5 bullet. Mr. Gwelani, whose death SAPs still have the gall to attempt to justify in paragraph 178 of their heads of argument, where they say he was, quote, clearly amongst the group of strikers who were attacking the police, or those the police could reasonably have believed were meaning to attack them, 250 meters away. Think of Mr. Mchamba, unarmed and terrified, huddling in the killing zone at scene 2 while SAP's bullets ricocheted around him and he was waiting to be killed. Think of the people who weren't as lucky as him. The 10 victims who also sought shelter in the killing zone but were shot dead by SAP's members, in circumstances where there's no evidence before this commission to suggest that they posed an imminent threat to anyone. Give them names. Mr. Mangotwa, victim D. Mr. Liao, victim E. Mr. Mosebetsani, victim G. Mr. Mabia, victim H. Mr. Nokamba, victim I. Mr. Sapendu, victim J. Mr. Ngande, victim K. Mr. Gadlela, victim L. Mr. Pato, victim M. And Mr. Mohai, who was wounded in the killing zone and died in hospital. And think of Mr. Mze, bleeding slowly to death for an hour at scene 1, while SAP's members mill around the scene offering no assistance, and Major General Naidu doesn't bring medical assistance to scene 1 because he prefers to join in the action at scene 2. Think of individuals, and try at all times to remember that every victim who died at Marikana, not just the 7 victims of the strikers leading up to the 16th of August, every victim who died at Marikana was an individual human being with a family and a life, an individual. And resist the attempt by SAPs to characterize the people they killed as undifferentiated members of a faceless mob. That has to be the starting point. So with that rhetorical opening, let me start with the more specific submissions. And on phase 2 issues, I'm not going to add anything to what's in the heads. On the issues relating to the 16th of August before the operation, that's the heading in our head. I'm going to stand by the heads. What I would emphasize is the submissions at pages 301 to 306, that the change from encirclement to the new tactical plan in all likelihood took place only between the 6 a.m. JOCCOM and the 1:30 JOCCOM. I've set out all the references there. I don't want to repeat them. I'd also emphasize the 3 major weaknesses in the plan that Colonel Scott was forced to cobble together on short notice. They dealt with at pages 326 to 330. Just to summarize, the first was the plan's dependence on a simultaneous rollout of barbed wire, something which, according to Brigadier Carlitz, was operationally impossible, or at least extremely undesirable. The second was the quantum leap in the plan from POPs methods to a line of 60 TRT members with military assault rifles who would effectively function as a firing squad. The third was the fact that the plan was likely to result in strikers fleeing to Kopi 3, but it provided no details of how to dislodge them from copy 3 once they got there. And as we argue in the heads, the first 2 floors in the plan led directly to the deaths at scene 1. The third floor led directly to the deaths at scene 2. I'd also emphasize the inadequacies of the briefing of the new plan. It's pages 345 to 347. And finally, I would urge you to look at the video footage of Mr. Matunjwa's second speech. Looks at that speech, at that video, and listens to the audio. It's important to listen to the audio. What we see and what we hear is a mood at the copy that has changed dramatically from lunchtime. There's none of the bravado that you see at 1:30, at 1 o'clock, none at all. What you see is people, what you hear is people singing a lament, and you see a lot of concerned faces.
Sorry, Mrs. Johnson, the second speech, what is exhibit?
Triple K 55, but it starts, Triple K 55 is a consolidated collection of ETV footage. The speech starts at 8 minutes and 28 seconds into that video. 8:28. 55. But I would urge you to start at 8:28 because otherwise you will, see a lot of aimless footage about, movement of SAP's vehicles on the morning of the 16th for 8.5 minutes before you get to the speech. If I can then move to our heads in relation to what happened at scene 1. And the first passage that I want to give particular attention to is a passage we address at page 363 under the heading, The Movement of the Strikers from the Western Edge of the Kraal and the Failure of SAPS to block the channel down the eastern edge of the Kraal. And by starting there, I must emphasize that what I have done is I have glossed over the parts of our heads where I deal with the start of the rollout, and also the heads that engage with Incident 1 and Incident 2. But why I've glossed over that is, subject to correction from my learned friend from SAPS, I understand from the SAPS heads that there is not much weight being put on Incident 1 or Incident 2 in the way that they were advanced in Exhibit L. And I don't see that much of a difference between our position and SAPS's position in that regard. If we go to page 363, it's necessary to get into some fairly minute detail at this point because the argument has to address whether it was possible for Brigadier Carlitz and SAPS in the field to have acted differently in the moment. And that requires focus on detail. And the starting point is when Nyala 4 reaches the edge of the kraal, because at that point, the strikers' attempt to get past the kraal on the western side has been stopped. That's 15:52:03. 15:52:03. It's 1 minute and 47 seconds before the shootings. Now, once that happened, there was only one route that the strikers could take if they intended to get into the SAP zone, and that was the route down the channel on the eastern side of the kraal. And on page 363, we have a diagram which is a photograph of the kraal which has passage A and passage B.
It's not absolutely right. If their passage movement forward was blocked by Nyala 4 at the western wall of the kraal, then there were two things they could have done. One was what they did, go around the kraal, proceed down the channel. The other was to go back and go towards the further, it would be to the east, would it not?
Yes, Chairperson, I'm not saying that through the passage was the only place they could go. What I'm saying is if they wanted to get into the SAP zone, which is what Brigadier Carlitz was guarding against, that was the only place they could get into the SAP zone. Of course, they could have dispersed north, west. They didn't have to get into the SAP zone, but Brigadier Carlitz had to work on the assumption that there was a risk that they would try to get into the SAP zone and had to deal with that risk. Now, the only place that you get into the SAP zone is down that channel, and there are two places where the channel can be blocked, relatively simply. It's Passage A and Passage B, which are marked on this photograph of Colonel Vermaak. Now, we submit in the heads, we discuss in the heads whether Brigadier Carlitz did order, the evidence in relation to whether he did order a block at Passage A or Passage B. It isn't conclusive either way, but our submission is that's not the real issue. The real issue is, could a reasonable commander in the position of Brigadier Carlitz have taken steps to block the strikers at Passage A or Passage B in time to stop the tragedy? And what we see is that whether Brigadier Carlitz did issue the order that sometimes he says he did and sometimes he says he didn't, the police vehicles didn't block Passage A. Instead, what they did is they arranged themselves in the crescent formation that we see on page 367. If we can just go down to figure 5 on page 367, where we see instead of blocking Passage A or Passage B, what they did is they formed a concentric semicircle around Passage A, or from Passage A to Passage B, leaving both passages open. And the first question that arises is a question that has been raised by the families of the deceased and the injured and arrested, whether was this a deliberate attempt to channel strikers down to the TRT line that we see in red? It plainly had that effect because it created a channel that opened out at a line of TRT strikers, but we conclude in our heads that this was not a deliberate plan. And we've set out why at paragraph 708. First is just a deep aversion to thinking that the operation involved what would be a deliberate, coordinated plan to murder large numbers of strikers. We'd have to see quite conclusive evidence to get past that aversion.
Sorry, my machine's on. Where you said, was there an attempt to murder them effectively? Yeah, and to that has to be added, was there an attempt, was there a plan to kill them in front of the TV cameras?
Indeed.
Media houses are going to go all over the world.
Indeed, indeed.
That's a further factor
that is an important. It is an important factor that we overlooked and obviously adds weight. The second point we make is it would have required such a wide degree of cooperation in implementation that we would have expected to find some evidence in it from a range of SAP's officers who would have to have been involved and whose bona fides we can't question. So we would have expected, if it was there, that it would have come out that way. We also, at the risk of not being humble enough, think that we've done a fairly exhaustive investigation into all of the documentary and electronic evidence that we could find, and the fact that we found no trace of such a deliberate plan in all of our investigations suggests that it wasn't there. And finally, we just think that the planning and execution of a plan like that would have had to be so precise and so slick that we don't think that SAPS was up to it. If we look at the conduct of the SAPS operation through 13th and 16th, or the SAPS operations through 13th and 16th, if this was a deliberate plan, it would have required a level of organization and efficiency that they just didn't show at any other stage over the week. But that doesn't mean that we regard SAPS and its commanders as free from culpability in relation to what happened. Because, as we say in paragraph 709 and 710, it's our submission that a reasonable operational commander in the position of Brigadier Carlitz, upon witnessing what he calls Incident 2, would have anticipated the possible need to seal off the safe zone by closing the access routes through passages A or B, and it would have been reasonably possible to do so.
The problem with that argument is that you say Incident 2 didn't happen.
Well, No, Chair, let me...
So one has to reformulate it. I'm not saying it's necessarily fatal to the argument, but it's got to be reformulated. You can't say, well, if he saw Incident 2, you would expect him to act as follows. If you say in the same breath, or almost the same breath, that Incident 2 didn't happen, what you've got to do, if you're going to put up the argument, you've got to say what happened in place of Incident 2.
Yeah, well,
and you must base the argument then on that.
Yeah. What we say he did witness, or what he may have witnessed, and what certainly did happen, is that the strikers tried to enter the police safe zone along the path to Nkaneng on the western side of the kraal. That has always been our submission. Where we've taken issue with SAPS is we have contested the version in Exhibit L that there was a showdown between SAPS and the strikers where POP's methods were deployed against the strikers at that point. We never suggested the strikers weren't trying to get onto the road to the path to Nkaneng at that point. But at the point at which Brigadier Carlitz saw the strikers trying to enter the SAP zone to the west of the kraal, and Nyala 4 cut them off, he should have anticipated, and in fact he says he did anticipate, that there was a risk that they would then go round the kraal and try to enter on the eastern side of the zone, eastern side of the kraal.
Interrupt you, just to elaborate the previous submission, it may be quite important. If one accepts, as you do, in your argument, that the police believed that there was an attack, whether there was an attack, attempt to attack them is a different question. But you concede that there was putative self-defense. And you also say, and you give the evidence, that there were threats. So the notion of a reasonable commander in the place of Brigadier Carlitz would have had a history of threats, would have seen the strikers trying to enter the police zone, as you say, and would presumably, in the circumstances, have been entitled to accept that there was a distinct possibility that they were minded to attack the police, in other words, to implement the threats that had been made earlier. So you don't have to go to the extent of saying there was some kind of Incident 2. The factors I've mentioned would be enough to make a person in Brigadier Carlitz's position accept that what might happen would be an attack, an attempt to implement the threats, and precautions must be taken to ensure that doesn't happen. Would that be a formulation that you would go along with? Or
yes, one doesn't even need to go that far, Chairperson. The whole SAPS plan was predicated on a need to keep the strikers out of the SAPS zone. That was the whole purpose of the barbed wire deployment. Now, once the strikers had shown an inclination to get into the SAPS zone, and you cut them off on the west side, a commander implementing that plan would anticipate a risk that they would try and go around the kraal and enter on the east side and would need to cut them off there. The plan, the logic of the plan was that strikers must be kept out of the SAP zone because there is a risk that if they are get into the SAP zone, media and SAPs might be attacked by the strikers. That was there from the very beginning. Now, if we start looking at Passage A and what could have been done to close Passage A, the starting point is always the point at which Nyala 4 reaches the western side of the kraal, because at that point the only remaining opening is Passage A. Nyala 4 reaches the kraal at 15:52:03, and the reference is in footnote 1106. By the time that Lieutenant Colonel Vermaak's aerial photograph at slide 205 of Exhibit L is taken, the famous aerial photograph of the strikers approaching the channel, that's 15:53:26, and the strikers are still a few seconds away from reaching Passage A. So it's 1 minute 23 seconds after Nyala 4 closed. What's happened in the 1 minute 23 seconds is that 8 armored vehicles have driven round the kraal and have taken themselves to a position which is actually further in the channel than they would have had to go if they were going to block the channel. So if we look at the position of Papa 7, Papa 18, Nyala 6, Brigadier Carlett's own Papa 1, Papa 9, and the 2 Caspers. They've all driven from the west side of the kraal to the east side of the kraal a further distance than they would have to drive if they were forming a block at Passage A.
Sorry, Mr. Justin, is Nyala 6 the one, if one looks at the bottom left-hand corner of the photograph, is Nyala 6 the third vehicle up there? It looks like it, because I think...
Yes, it has a little trailer behind it.
Now, in the presentation by Lieutenant Colonel Scott, he said something that wasn't dealt with in the evidence, because people didn't come from Nyala 6 to give evidence. You say the original idea was that Nyala 6 was supposed to uncoil the wire to block the passage. That's what Lieutenant Colonel Scott says in the presentation. The point was taken no further. But I was reading it the other day. I was wondering why it didn't happen. But I don't know whether we're able on the evidence to answer that question.
Well, on the evidence, we can't answer why it didn't happen. What we can say is that, and I was going to get to it in relation to Passage B. If one looks at whether Nyala 5 or Nyala 6, because remember there were 2 barbed wire Nyalas on that slide, whose position we can see in the slide in Exhibit L, the Lieutenant Colonel for Mark's slide. It's a 201. Yeah, sorry, 205. No, not 205. It's the earlier one. The incident, if one looks at the BlackBerry photograph of Lieutenant Colonel for Mark that shows Nyala 4 racing to get to the kraal, you can see that Nyala 5 and Nyala 6 are both in a position where it would be relatively easy for them just to drive straight forward if they could unfurl their barbed wire and seal off the Passage B, not Passage A, Passage B. And the question then arises, was there enough time for them to do it? Because Brigadier Carlett suggested it would all have happened too quickly. We, with respect, disagree. And what we use as our comparator in this regard, and it's not in the head, so I should just highlight that.
What you're saying is being recorded and will be transcribed, so I think we don't write it down.
If we look at how long it took Nyala 4 first to get its barbed wire ready for deployment, and then to travel what was almost 100 meters from the mast to the kraal, we can assume that Nyalas 5 and 6 would have been able to perform the same exercise quicker, because they had to do the same job of getting that barbed wire triangle out and the barbed wire ready to deploy, but then the distance that they had to travel from the position where they were when they were passed by Nyala 4 was, in the case of Nyala 5, approximately 75 meters, in the case of Nyala 6, approximately 67 meters. So it was a shorter distance than that ultimately traveled by Nyala 4. The deployment of the Nyala 4 barbed wire took no more than 39 seconds to operationalize, as it were, because we see Nyala 4 stopping at the mast away from Nyala 3 at 15:50:48. And my references for this will come from the raw footage, will come from Exhibit Quadruple U 10.3 Annexure V2. So at 15:50:48, which is 10:19 on that video, Nyala 4 has moved away from Nyala 3 and stopped at the mast. It's only going to, at that point, take its barbed wire triangle off. Nyala 5 will then come up to Nyala 4, and then it will be wedged onto, Nyala 3 will then drive up to Nyala 4, it will then be wedged onto Nyala 3, and then Nyala 4 will drive away. So it reaches the mast and stops at 15:50:48. It's already deploying its barbed wire 39 seconds later, 15:51:27. Sorry, 49 seconds later, 15:51:27. That's at 12:01. And then to travel the 100 meters, it takes 35 seconds. It starts at 15:51:27, it finishes at 15:52:03. So the whole process takes 1 minute and 15 seconds. From the point at which it takes its triangle down to the point at which it reaches 100 meters away. 1 minute and 15 seconds from the point at which Nyala 4 reached the kraal would have allowed Nyala 5 or Nyala 6 to close passage B a full 30 seconds before the shooting. So if Nyala 4 could do what it did in 1 minute and 15 seconds, Nyalas 5 and Nyala 6 could have done the less that they needed to do to close passage B in 1 minute and 15 seconds, and that would have protected the safe zone more than 30 seconds before the shootings. But that was a bit of a digression, because in truth, the easier way to stop the strikers would have been to block passage A. And that could have been done using the block method that was effected first to the west of the kraal before Nyala 4 came, and Brigadier Carlitz described that method of vehicles driving side by side with space for members to debus between, possibly a meter apart. If one looks at the distance of passage, the width of passage A, it's measured at 19 meters at the inspection. If you assume a Casper or a Nyala width of 2.5 meters and a distance of 1 meter between them, you then need only 5 armored vehicles to block passage A according to the standard block method. And as we've already seen, there were 8 armored vehicles that had already driven further than they would need to have driven to block passage A by the time that, or before the time that the strikers entered passage A. So if an immediate instruction to block passage A had been effectively communicated and implemented, it would have been possible to block passage A with 5 of those 8 vehicles. One wouldn't have needed the last 3 before the strikers got there. In relation to passage B, a block would have been simpler because there was more time for it. We talked about the barbed wire. One could also have blocked the 23-meter passage B using the standard block formation, which would have required no less than, well, no more than 8 vehicles at a maximum, probably just 7, and we had all of those 8 that could have been used. In addition, there would have been Papa 2, Papa 4, Papa 5, and Papa 10, all of which had crossed passage B by the time of the shootings. And the other way that passage B could have been blocked is, because of the geography, it would have been very easy to block passage B by driving the Nyala vehicles head to toe as opposed to side by side. That was something which Colonel Scott conceded in cross-examination. It would have required only 5 Nyala vehicles to block passage B. So our submission is that it was possible to prevent the shootings by blocking either passage A and passage B, and there hasn't been a satisfactory explanation from SAPS for their failure to do so, and in particular for the failure to orchestrate the armed vehicles in a way that was designed to achieve what apparently they were supposed to be doing, rather than this strange crescent formation that channeled them down towards the TRT. The second important submission in relation to...
So Justice, how long is the second important submission going to take? I was proposing to take the lunch adjournment now for half an hour, but if
it will take more than 2 minutes, Chair.
Right. Well, shall we try to resume at 28 minutes past 1? We will adjourn for lunch. Commission resumes. Before Mr. Shasterson continue with his argument, I want to deal with the question of the unavailability of simultaneous translation services. I raised it with the Office of the Secretary of the Commission, and he... I said we'd start at 28 minutes past. And he has asked me to apologize for the unavailability of these services this morning. He asked me to put it on record that all processes were followed through the Department of Justice and Correctional Services to secure simultaneous translation services with effect from this morning. And the service provider who was contacted confirmed his availability, but for some reason that is not yet known to the department and the Office of the Secretary, these services were not provided today. Attempts are being made to ascertain the reason for this. But they haven't been able to contact him. I'm also asked to draw to the attention of everybody concerned that this situation is only temporary, that all efforts are being made to get such services, either with effect from tomorrow or certainly with effect from Monday. But the Secretary of the Commission has again asked me to repeat his apology for the inconvenience that was caused. And I trust that that is an explanation which will be duly noted by all those concerned. Mr. Shasterson.
Thank you, Chair. I'm moving now to look at the use of POPs methods at Scene 1. It's addressed from page 370.
We get there. I don't know if you're going to deal with this later. You were saying what could have happened at Scene 1, what didn't happen. Are you going to deal in due course with the evidence, not only from Brigadier Carlitz, but also I think from Colonel Marafi, that the order block was given? You are going to deal with that? 'Cause that
is that it may have been an unplanned, uncoordinated, one Nyala goes out as far as possible and then everybody else just stops behind because nobody knows what they're expected to be doing. That is a possibility. But we're really speculating because we have no evidence as to what explains that arrangement.
What was the arrangement of the vehicles at the time when Brigadier Carlitz left the scene, according to his evidence?
Left scene one.
Yes, left scene.
That's the arrangement that we see on page 367 of the heads. That's just at the point of the shootings, and so you have the inner crescent, and you have Papa 7, Nyala 6, Papa 18, and Papa 1 spread out behind the crescent.
Thank you. They put it up. I see it on the screen. I was looking for it in my copy of the heads. If that's the figure 5 of your heads at the end of paragraph 704, if that reflects the position which the vehicles were at the time when Brigadier Carlitz left, it indicates that the crescent formed by Brigadier Carlitz was on the scene. So, inasmuch as he was the operation commander, if that crescent formation came about because of an order by somebody, he was the logical person to have given the order because he was still there. That seems to be correct, does it not?
The crescent had definitely started to form when he arrived at the scene, because there's that footage that we went through in his cross-examination of his vehicle arriving at the scene and turning to go right outside Nyala 6, which at that stage was a little further back, while the inner crescent is starting to form up. There's the two Caspers and a Papa 4 have formed up, and Nyala 6 is next to Papa 4 when Brigadier Carlitz arrives, and he goes outside, or his driver goes outside. But his evidence at the time was that the decision on where to go to was his driver's. It wasn't his. It wasn't.
So what you're saying is that the crescent had already begun to form when he arrived. So if it was formed because of a command by somebody, it wasn't him. It wasn't he who gave the command. It was
not necessarily, Chairperson, because he could have given that command on the radio while he was moving from his original
so
position.
there's three possibilities. He either gave the command as he was on his way there before he arrived there, or somebody else gave the command, someone else who was presumably in charge, as it were, under him in that vicinity. Or alternatively, it was something that just spontaneously arose, one vehicle following another, as it were. Are those the three possibilities?
Those would seem to be the three possibilities. The one submission that we would make is that the positioning, the crescent formation should have been visible to Brigadier Carlitz when he arrived at the scene, and he would have been in a position to change it as operational commander if he didn't like the crescent formation. He stayed on the south side of the path to Nkaneng while that crescent formation, while the back end of that crescent formation was being formed up, before he crossed over the path to join into a position to his right of the crescent formation.
Yes. And the other point is, I think you've said it already, I just want to make sure I understand. There's no explanation as to why the block didn't occur. An order may or may not have been given. I think Marafi says the order was given, and Carlitz, not Marafi, sorry, Mary. Somebody says, let's make sure I've got it right. Somebody apart from Carlitz who was there says an order to block was given. Am I correct?
I think there is a statement from either Pizzi or Mary in which I've seen that. I can get the exact reference.
We can check it. Thank you. And there's no explanation as to why the block didn't happen. I seem to remember, I asked Brigadier Carlitz, but I don't remember that he gave me an answer that I understood, but perhaps we can find that in the record.
The problem with Brigadier Carlitz's evidence is it's quite difficult to understand what he had in mind. Well, one, whether he prevaricated on whether he gave the order to block or not, and also what he wanted to block. Because when we were playing around with blocks on the map, it was clear he selected the passage A as the place he wanted to block, but he later retreated from that proposition. So there isn't a single or consistent explanation from Brigadier Carlitz on this.
Yes. Thank you, Mr. Chairman.
The next issue that I want to emphasize is at 376 of the heads, which is how late non-lethal POPs methods were actually used at scene one. And the references are all in the heads, and they are references to the raw footage of the quadruple U videos. And I should place on record that at points in our heads we've attributed the quadruple U videos to CALS. They are actually a joint production of CALS and SERI, so it's families as well as Human Rights Commission who should be credited with quadruple U. The important points there is that the video evidence, we say almost conclusively, or we would say conclusively, shows that up until 20 seconds before the shootings, there had been no tear gas, stun grenades, or water cannon used. And when tear gas, stun grenades, and water cannon finally get used in the last 20 seconds, there are two important points to be aware of. The first is that they do have the effect, the first is that they're being used too late, because by that stage, the lead group of the strikers is already in the channel. So if they are designed to prevent the strikers from getting into the channel, it's too late to use them. But the second is they do have the effect that they are supposed to have. They disperse that group. They break it up. The problem is, because the group's already in the channel, and the tear gas and the stun grenades are deployed not between the TRT line and the front of the group, but rather towards the middle of the group, what they do is they break the group into two different directions, and possibly three. And that's the issue that we discuss in some detail at pages 377 through to 379, or 381 of the heads. But it's possibly best illustrated by the diagram at page 379. So if we could go down to
before I
page
get there,
6.
can I just put a point to you? Would it be fair to say that the fact that tear gas and stun grenades were used, albeit too late, only 20 seconds before the shooting, the fact that they were used tends to indicate that the police didn't intend to massacre the strikers. They in fact intended to disperse them. They did it inefficiently, they did it too late, they did it at a time when half the group, I don't know whether it's actually half, but certainly the front section of the group were forced forwards as opposed to backwards. But the fact that they were used at all is evidence which would tend to show that the police didn't deliberately set out to kill the strikers. They in fact tried to disarm them, tried to disperse them, but they did it too late with the consequences we know. Would that be a fair statement?
We would accept that, Chairperson. And the use of POPs methods and their effects we see in Figure 6. And Figure 6 is a still taken just at the point of the shootings from the JJ194 series. And the points that I would emphasize are the 2 points that are marked by the vertical red arrows, that if one looks between the nyalas, if one looks at the vertical arrow on the left-hand side, one sees that between Papa 2 and Papa 4, there are no strikers. In fact, the sort of front group of Mr. Noki and 11 others has already moved to the left of that red arrow. If one were to see the video, one would have seen them passing through that gap earlier on. But there are no strikers visible in the gap. So there is at least that gap between Mr. Noki and his 11 co-leaders and what we call the Kral group. And if one looks at the gap between the Pops Casper and Papa 2, with the red arrow on the right, one sees a single striker who is in a gap between what we have called the Kral group, which is behind Papa 2, and the rest of the original group of 100 more strikers that came round the Kral. So at the moment of the shootings...
They would be behind the Pops Casper, would they?
Well, they would be behind the... Yes, they'd be behind the Pops Casper, and some of them would actually have been retreating north and west. So the use of these Pops methods has already broken up what started out as a single group of more than 100 people into 11, 12 people at the front, a Kral group of, I don't know how many people, maybe another 15, 16 who are now behind Papa 2, and a rump that is behind. And what that suggests to us is that if the Pops methods had been used quicker, and in particular before the strikers had entered the channel, it may well have been possible to disperse this group and to effect the Pops operation that SAPS wanted to effect, because the Pops methods did break up the group. The problem was it broke up the group at too late a stage, and part of the effect of stun grenades and tear gas behind the lead group was to push them forward into the direction of where the TRT was.
Though some of the strikers are not deterred by the tear gas.
It's certainly an argument that's been put forward by SAPS, but Commissioner Hemraj, I'm not sure that that is so. The strikers, if one looks at the Kral group, and this is speculative, I must concede, but the Kral group that one sees now behind Papa 2 seems to have been, there is a tear gas canister that has just been fired behind Papa 2. One can see the tear smoke rising up above Papa 2. The strikers in front of it are moving away from it towards the police. The strikers who are not in front of it are moving away from it towards the Kral edge. That's how they end up on the Kral edge, we speculate. And I must concede it is speculation. But it's speculation that makes sense, because if one scrolls this video, well, this is a still, but if one were to scroll the video back, one would see 20 seconds earlier, the first stun grenade has been fired, and the Kral group and the lead group have not been separated yet. They have moved away from the stun grenade behind them as one group, whereas everybody else has backed off from the stun grenade. And so there's a gap that's opened out between the consolidated lead group and Kral group and the rest of the strikers. And when the tear gas starts to come in, breaking up Mr. Noki's, well, breaking up what was a consolidated lead group, Mr. Noki and 11 other people who are in front of where the tear gas is fired move further in front of it. The Kral group moves away from it towards the Kral, sort of sideways away from it. So, and if one looks at that photograph that one sees in quadruple U 10.3 of that lead group of Mr. Noki and the other 11, just at the point of the shootings, they're all huddled down. I mean, they are bent over forward, and it's quite possible that that is in part a reaction to the tear gas. There's certainly no evidence that there are strikers who are immune to tear gas that we can see. There's no clear evidence of people walking through tear gas with impunity. It's not clear to us where the evidence for that argument advanced from SAPS comes from. What does seem clear is that the use of blankets, whether deliberate or otherwise, is a protective device against rubber bullets, that a rubber bullet doesn't penetrate a blanket, or a blanket insulates you against a rubber bullet. But tear gas seems to us not to be something that the strikers were resistant to.
It wouldn't work like it. Anyway, you can't say that, I don't think anyone can say, that people are immune from tear gas. Tear gas doesn't affect them. The question of impunity, it doesn't arise. From a physiological point of view, tear gas would cause extreme sensations of discomfort and so forth. The only question is whether someone faced with tear gas would, as it were, close his eyes, put his hand over his nose, and put his head down and move forward, despite the fact there's tear gas, or would take some steps to try to avoid it. But certainly I don't think it's physiologically acceptable to say that tear gas, there are some people who aren't affected by tear gas at all. And possibly if you've got a blanket to protect you against the rubber balls, you would pull the blanket up as well over your face to try to protect yourself from getting tear gas. But you can't go beyond that, surely.
And the one submission that we would emphasize is we haven't seen evidence of strikers just advancing through tear gas with impunity, moving towards tear gas.
Impunity is the wrong word. I can understand people possibly closing their eyes, putting something over their noses, putting their heads down and moving forward despite the fact there's tear gas. But that's a different proposition from proceeding through tear gas with impunity. That's the only point I'm making.
The next topic that we want to address is the question of intention. And that's addressed at 383. And the single most important submission that we make in this regard is that it's tempting to impute a single intention to every individual in this group that set out from the Kopi and eventually made its way around the kraal. But there just isn't evidence on the basis of which one can assume a common intention. Still less a common intention to attack the police. And we readily concede that some members of what has been called the lead group may have intended collectively to attack SAPS after Mr. Matunjwa left the Kopi. That may be a possibility. We don't know. But there is not any convincing evidence in our submission of a single common intention on the part of all of the members of the group that left the Kopi to attack the police. Different members will have had different intentions. Some may have been looking to attack SAPS. Others may have been looking merely to get away from SAPS to Nkaneng. Others may have been looking to, beat a dignified retreat in a collective fashion. Others may have had intentions somewhere between the two. One to retreat collectively with dignity, and one to get to Nkaneng. If the SAPS get in our way, we will shoot or hack. Certainly, there is at least one member of the group who was prepared to shoot at SAPS. We've seen it. And we say it's very important for the purposes of this submission to try to focus on individual members of the group and see what individual members of the group do. And it's quite a tricky exercise because one has to identify the same person through various bits of footage. But the example that we give in the heads is of Mr. Nsenyeho, who was a leader of the strikers, or was apparently a leader of the strikers. He spoke both on the 13th and on the 16th, and he was one of the people who was killed on the 16th. And we track his movements through paragraph 727, what he's doing, and we reach a conclusion at 727.11 on page 387, where we emphasize the fact that as he approached the kraal, where he was going to be killed, Mr. Nsanyeho had no weapons in his hands. That is absolutely clear. He wasn't carrying weapons. And in the circumstances, he personally couldn't have been intending personally to attack the heavily armed SAPS members around the kraal. That's just not conceivable. And much more to the point, he himself could not have posed an imminent threat to the SAPS of an order that would have justified his killing. He had no arms, no weapons. And we would caution at this point that it is very important not to conflate individual or common intention or even common purpose with objective threat, because they're two separate categories. Common purpose is a category of the criminal law which determines whether you can be held criminally responsible for acts that other people pursue or perform pursuant to your common purpose. It's a category for criminal liability. It's completely irrelevant to questions of whether your killing can be a justifiable homicide. For your killing to be a justifiable homicide, it has to be necessary to avert an imminent threat. And there is this conflation of common purpose with grounds for justifiable homicide in the SAPS heads. In particular, at pages 41 to 42 of the SAPS heads, paragraph 102, where they talk about why the killings at the kraal were justified. And really, it's an argument at its high point about why the strikers at the kraal had a common purpose. Well, that doesn't justify the killing of Mr. Nsanyeho. Even if Mr. Nsanyeho did have a common purpose with other strikers, and even if that common purpose was for the other strikers to attack the kraal, Mr. Nsanyeho himself, and we don't say that he did have that common purpose, but even if that were to be proved, he himself posed no threat to anybody. He had no weapons. His killing just wasn't justified. So, when it comes to justifying a killing, a case has to be made out that there was an imminent threat from the person who was killed. Not that the person was part of a group that may or associated himself with a group that may or may not have had some members who posed an imminent threat. Justifiable homicide is an individualized inquiry. And that is a very, very, very important submission on our account.
Where would Mr. Nsanyeho be in that group that approached?
He was in the kraal group.
Behind Mr. Noki's group.
So the front 11 were Mr. Noki and 11 others. Then there were the people who ended up being shot with their bodies up against the kraal. Mr. Nsanyeho is at the back of that group. He's a very easy person to follow through the video footage for two reasons. The one is he's very tall, so he stands out. But the other is he's wearing a string yellow backpack, a Bafana yellow backpack right through his walk from the kraal. And so there is this bright yellow backpack on his back, and you can see him when he's walking, whether he's facing you or he's turned away, and you can see his body at the back of the bodies against the kraal by the yellow backpack. The next...
Sorry, Mr. Would you say then, therefore, that the killing of Mr. Nsanyeho was aimed at killing him, or it was just in the midst of bullets directed at the group?
Commissioner Tokota, that's the topic I'm coming to right now, which is the case of justifiable, well, the case of putative self-defense, and where it's justifiable and where it's not. So if I can address that answer in that context, because it's important for us to...
Before we get there, can I ask you this? The gentleman, I forget, you mentioned his name a minute ago, but I can't remember. Mr. Nsanyeho. So he had no weapons in his hands. Would that have been visible to anyone in the TRT line?
Well,
or the POPs people, for that matter.
it certainly would have been visible to the POPs people. Maybe if we can go, if I go back to one of the photographs where one can see him. If one goes to figure 7, page 380. Mr. Ntsonyeho is the tall man to the right. He's the man in the brown jersey with a light diamond pattern running down the front. You can see his left arm at his side. He's not carrying a weapon. This unfortunately is not the shot that I was hoping for. But you can see in this video clip that at the point at which rubber bullets are fired in the direction of this group, he turns and looks straight at the SAPS people, and both of his hands are visible. I think there's a reference to the specific somewhere in paragraph 727. No, I haven't got the exact reference, but both of his hands at his side are quite often visible in this video without weapons.
POPs people could see he wasn't armed. POPs people on this side anyway could see he wasn't armed. The question related to the TRT people also.
Yes. Well,
they would have seen a group of people approaching. At the end, they would have seen about 12 people, presumably, plus possibly the Kral group as well behind. But the ones they would have seen immediately in front of them would have been Noki and the other 11. They would have seen some of them with weapons, I take it. Would they have been able to see that he didn't have weapons?
They may or may not have been able to. They probably would not have, because 4 seconds into the shooting, there is so much dust kicked up that you can't see anyone beyond the people right at the front who are falling down. And Mr. Ntsonyeho may not even have been, would not have been visible to the TRT before 4 seconds into the shooting, and after 4 seconds he wouldn't have been. But that again comes back to questions of proportionality, which I'd like to address in...
Yes, I understand that. You're going to get to that in a moment. And once there's a dust cloud and once people are seen to be falling in the front, then you would argue that whatever may have been justifiable up to that point, the firing should have ceased.
That's correct, Chairperson. And it... I'd like to get to it first by qualifying what our case is in relation to putative self-defense. And we set out why SAPS members in the TRT line would have had a reasonable belief to assume that they were facing an imminent attack at the point at which suddenly the Nyala 10, I think it is, goes out of the way and they see themselves face to face with Mr. Noki and his group, who are sort of running towards them, in fact, or quite possibly running away from a tear gas canister behind them. But the submission that we make is at paragraph 744, 399, page 399, and I would want to emphasize what the submission is. The first members of the TRT to fire at the approaching strikers would have had reasonable grounds for believing that they were under imminent threat of violent attack. And we've said why that's the case in paragraph 733 on page 394. They would thus have had a case of putative self-defense if they fired in a manner which was calculated to stop the putative attack without creating an unnecessary risk of killing the strikers. And that's where the proportionality comes into putative self-defense. And in this regard, what our submission is that the case of reasonable putative self-defense would be confined to the lead group of 11-12 strikers. Those were the ones who would have been seen immediately approaching the TRT line. It wouldn't apply to the kraal group, not to the rump of the strikers who'd been separated from the kraal group already, and certainly not to the strikers on the other side of the kraal. And then the question becomes, given the ambit of the legitimate claim of putative self-defense, was the shooting that followed proportional to allow a claim of putative self-defense? And that's the issue that we address at 748 on page 402, where we say, it is clear that there was considerable shooting which exceeded the bounds of reasonable self or private defense for the following reasons. The first is that inadequate care was taken to shoot at lower limbs, and that's clear partly from the number of victims who are shot in the upper body, and some visual evidence. One can see, for instance, Warrant Officer Kuhn, as he stumbles backwards, is shooting at head height, and continuing to shoot at head height after he gathers his footing. And all of the victims who are killed a long way away from the kraal are killed by bullets which are not ricochets and which hit them above chest height or at chest height or above. So there are bullets being fired with R5s at chest and head height in circumstances where they can travel 250 meters and take out Mr. Gwelani. Now that is disproportionate to the threat of self-defense. To the claim of self-defense. There's also evidence that shooting continued beyond the point at which a reasonable police officer would have stopped shooting. And here I must concede that, well, I must respond to a criticism in the replying heads of argument of the Human Rights Commission, which says we speak of the 8-second shooting. We readily concede that there were shots that continued beyond 8 seconds. The volley lasted 8 seconds. The sustained volley lasts 8 seconds. There are isolated shots that are after the 8-second volley. There's an obvious one that one can see at 15:54:02, which is 12 seconds, on the SABC footage in quadruple U10, in Annexure V1 to quadruple U10, which has the raw footage from each of the different streams. If one goes to 15:54:02, one sees a member of the TRT line shooting an isolated shot 12 seconds after the volley has started and 4 seconds after the volley has ended.
Is it possible to identify him?
Well, it may be.
Maybe we can't, but
Yeah.
The reason I ask these questions is that, and this obviously is a question of criminal liability now, not civil. If it's reasonably possible that the shots fired in the first couple of seconds caused the deaths, then people who continue to fire after that would not be guilty of murder, although presumably we can't say anyone was guilty of murder because we can't link any bullet to any body. But after the first few seconds, 2 or 3 seconds perhaps, the most you could have would be attempted murder. But I suppose the answer to that is that in any event, even respective the shots fired in the first couple of seconds, because we can't link them to bodies, no one could be charged with anything other than attempted murder, unless there's some basis for imputing common purpose to all the shooters. But I'm not sure that can be sustained.
Chairperson, if I can respond to that, because it does get ahead to a point which I did want to address in these submissions, which is to also to respond to a criticism of our heads from other parties in relation to our recommendation that no individual SAPS members, that no criminal sanctions be taken against individual SAPS members arising from the killings at Scene 1. It's a topic that I would like to address in some detail, but if I may do so now, because I think...
One of the matters I wanted to ask you about.
We've looked at the evidence in relation to individual SAPS members who shot on the 16th, and we cannot link any individual SAPS member to the killing of strikers in circumstances where prosecution of that individual SAPS member is likely to have any prospects of success in relation to either murder or culpable homicide.
Hang on. Leave out murder and culpable homicide. You can't link a body to a bullet.
But Chair, I do want to answer this fully because people have made this criticism, because there are bodies that can be linked to bullets.
I see.
At scene 1, there are 3 bodies that can be linked to bullets, or there are 3 bullets in bodies that can be linked to shooters at scene 1. There is a bullet in Mr. Sompeta, who is body G at scene 1, a bullet in Mr. Lehupa, and a bullet in Mr. Yawa. But in all 3 of these cases, the bullets that are retrieved from the bodies are 9mm bullets, and the post-mortem reports reveal that the strikers were also shot by R5 bullets, which either were definitely the fatal shots, or possibly also the fatal shots with the 9mm. I think in Mr. Yawa's case there is a 9mm bullet that hit him in the heart and an R5 bullet that hit him in the heart. But the point is that one cannot show that one is not going to be able to show in a criminal trial that the 9mm bullet that was retrieved from the body in any of these cases caused the death beyond reasonable doubt. At scene 2, the only cases where shots from a particular SAPS member can be linked to the death of a striker is the case of Mr. Mpumza. But there a case of private defense or self-defense, in our view, is likely to succeed. We don't see a prospect of a prosecution succeeding in that phase. But having said all of that, and this gets back to your point, Mr. Chairperson, is that it struck us that there is a double standard in our heads of argument between the attitude that we take to strikers who can be identified as unlawfully assembling with dangerous weapons and SAPS members who can be identified as shooting recklessly at scenes 1 or 2 or even on the 13th. Because in relation to the strikers who unlawfully assembled with dangerous weapons, our submission is that they should be charged because it is important to stamp out armed assemblies. By the same token, we accept that we should be making a submission that all SAPS members who shot recklessly should also be prosecuted because there is a need to stamp out the reckless use of firearms in SAPS operations. And so what we would ask the Commission to recommend is that in all cases where reckless SAPS shooters can be identified by IPID, either from the video footage at scene 1 or from their own warning statements, where they explain their shooting in circumstances that prima facie amount to reckless shooting.
Where they fired so many shots that the only inference is some of them admitted, of course, but the only inference is that the firearm was on automatic.
Yes, well, there are 3 SAPS members who concede that their firearm was on automatic. What our submission is...
Those would prima facie be cases of attempted murder, I would have thought.
Or at the very least, Chairperson, a contravention of Section 123B or 127 of the Firearms Control Act that relates to reckless shooting or reckless shooting in a public place.
As I think you've said, all we need is sufficient evidence to justify a prosecution, which would be a prima facie case. That's all we need to make a recommendation to the provincial DPP, who will then obviously have the matters investigated more fully. And if he's satisfied that there's a prima facie case, then he will do what has to be done. What is it?
So those are our submissions in relating to the shooting and in relation to putative self-defense. I have one last submission that I want to make in this context, which is putative self-defense is relevant only to the position of the individual shooter. And it's not dispositive of the responsibility and liability of SAPS as a whole for other failings that led to the shootings. For instance, poor planning, failure to execute at an operational level, and so on. And there is something of a debate in relation to the McCann principle of the European Court in the heads of argument, which we haven't engaged with. We would submit that the McCann principle is likely to be followed by South African courts. It's a principle that is solid at the level of general principle. And what it says is one doesn't look just at the conduct of the individual shooter, one looks also at whether the planning and implementation of the operation was done with reasonable care to minimize the risk of loss of life.
Let me put a practical example, which I would have thought, again, prima facie indicates that principle or a variant of it should be part of our domestic criminal law, if I can put it that way. Assume a dangerous homicidal criminal is running loose in a building. Let's assume police headquarters. And he's running down a passage, and he's coming to a T-junction. He can either go left into a room, which the door can be closed behind him, and he can then be overpowered there without difficulty. Or if he goes right, he will go right into an office where there are 5 policemen, each of whom is armed, each of whom may well be under attack from this homicidal criminal, and who will have to defend themselves. Now, clearly, if they defend themselves, if those responsible for planning the situation don't see to it that he goes left into the room where he can be overpowered easily, but allow him to go into the right-hand room, and if they foresee that it's reasonably possible, if not likely, that he will be involved in an attack on one or other or more of the people in the room, and they foresee that they will be obliged to defend themselves and that he will be, in all probability, killed, then the question would arise is the person who allowed the homicidal criminal to go into the room on the right and didn't take steps to make sure he went to the room on the left, is that person not guilty of murder? Or if there wasn't subjective foresight, would then be guilty of couple homicide. What principle can be invoked to avoid that conclusion? All the elements, I would imagine, of the definition of murder or couple homicide, as the case may be, would be present.
That would be our submission, Chair, and we would like to refer in this regard to a judgment of Madlanga AJP, as he then was, before he was Madlanga evidence leader and before he was Madlanga J in the Constitutional Court. It's the case of Ntamo versus Minister of Safety and Security, NTAMO, 2001, Volume 1 Essay, 830. 2001, Volume 1, 830.
830. TK, I take it.
TK. And it was exactly the situation which we are contemplating, which is the police killed killed a wrongdoer in circumstances where it was necessary to do so in the heat of the moment, as it were, in self-defense and private defense. But that situation, where the wrongdoer had been allowed to get to a situation where he had to be killed in self-defense or private defense, was because the police had completely negligently approached the planning of how to arrest him. And at paragraph 27, Justice Madlanga said, "From the aforegoing, it's quite plain that the shooting of the deceased by the police was precipitated by their wrongful conduct. The police cannot seek to justify the shooting on their own wrongful act. In my view, the fact that at the exact moment when they shot the deceased, he was unlawfully firing at them, and they and possibly members of the public as well were therefore facing imminent peril, is not reason enough to ignore the hitherto wrongful conduct of the police. It may be argued with some force that the exact stage when the deceased started shooting at the police, they could not reasonably be expected to shoot back and thus sacrifice themselves. The point of the matter is that if the police had not acted wrongfully in the first place, see, for example, paras 23 and 24 above, for all we know, there might not have been any life-threatening shooting at all. And on that basis, the killing of the suspect was held to be unlawful." Chair, I'm rapidly running out of time, but there are a number of discrete points that I would like to make in relation to the rest of the heads on the 16th.
Just one short question, which I hope I get a short answer. You say that even if the police who fired at scene 1, and even scene 2, we won't go there, were able to invoke a defense of putative self-defense or something similar. Those who planned the operation would still be liable on the principle you've discussed. Now, who would they be?
Well, Chair, that is addressed in our section on our two sections on responsibility for the 16th and the punitive sanctions section, and the attitude that we have taken is that Colonel Scott can't be held responsible for a deficient plan that he produced, because he was put in an untenable situation. He was put in a situation where an artificial time limit was imposed on effectively planning an operation that was an incredibly risky operation to plan. And on our submissions on the evidence, it was at some time in the morning of the 16th that he was told, come up with a new plan. And he had to do that between the morning and the 1:30 JOCCOM, and the flaws in the plan in those circumstances are not flaws for which he should be held responsible. The real problem was the fact that this artificial deadline had been imposed on the situation, and that once a flawed plan had been put forward, the decision to proceed with the operation was taken nonetheless. And that was a decision of Lieutenant General Mbombo. And in relation to Scene 1, we say that Major General Annandale and Major General Mpembe cannot be held responsible because they were ordered to implement the operation by Lieutenant General Mbombo. And so liability would be confined to Lieutenant General Mbombo in relation to the decision to go ahead and run with the plan, in relation to Scene 1.
What about the members of the NMF who endorsed the proposal?
Well, we thought about the members of the NMF who endorsed the plan. Our difficulty in relation to that was that we were of the view, and it was an issue that Mr. Budlander was going to address in reply, but we were of the view that there were too many potential sort of nova acta intervenientes, says Mr. Butler.
Novi actus intervenientes.
Because while at the level of factual causation, as we have submitted in the heads, that decision on the night of the 15th to go ahead to put an artificial time limit on this operation flowed directly to what happened. There were so many. One would have to regard the failure of people to speak out against the plan not as a novus actus. One would have to regard the failures in implementation of the plan as not as a novus actus as well, because the submissions that I've just made in relation to what could have been done at Scene 1 to stop the tragedy, if Passage A had been blocked. If Passage A had been blocked, there wouldn't have been people killed at Scene 1. So it seems to us that there are a series of intervening failures on top of the NMF failure that would probably break a chain of legal causation.
Wouldn't the Provincial Commissioner be able to rely on them?
The Provincial Commissioner may well be able to rely on that as well. We do...
You see, what concerns me is, there's also a concept of dolus indeterminatus, which hasn't been the subject of a recent decision elsewhere. And if you take a decision at the NMF and you know that there's going to be bloodshed, assuming you know what the criminal intelligence is, there's going to be resistance, people are going to fight to defend their weapons and their positions. You know there will be bloodshed. You say, never mind, let's carry on. Let's endorse the proposal. Haven't you got dolus indeterminatus?
We don't see an issue of dolus as being the problem. We see an issue of legal causation. Because certainly at Scene 1, our submission, our submission is that if the operational commander had acted reasonably at Scene 1, notwithstanding the deficiencies of the plan, the deaths at scene 1 would have been avoided. Because if that channel at passage A had been blocked, there wouldn't have been deaths at scene 1. If the channel at passage B had been blocked, there wouldn't have been deaths at scene 1. And that being the case, there may be, well, it seems to us that there is a break in the chain of legal causation between the decision of the night before and the deaths at scene 1. That may well...
What's the test for a break in the chain of legal causation? If the chain of factual causation was there, and must be, I take it, on the causa sine qua non principle, then, and the break is a result of some legal doctrine operating, what is the test for that? I think one of the most difficult questions in criminal law, but I hope you can give me a helpful short answer.
Well, can I suggest that this is an issue that we address in some detail in writing to be submitted before our replying arguments, where we will consider it, because...
Thank you. I think that's a sensible way forward.
Because the flip side of the break of legal causation, if there is one, would be that it would then be the negligence of the operational commander that was the proximate cause, as it were, of the deaths at scene 1, and then it would be Brigadier Karlitz who would have to be held responsible for those deaths. When it came to scene 2, and I'm jumping quite far ahead of myself now, our submission is that the position of Major General Annandale and Major General Mpembe is not the same in relation to scene 2. Because the risks of what happened at scene 2 were inherent in the plan. That's the submission that we made in relation to the plan's failure to deal with Copy 3. And while at the start of the operation, they were not in a position to say we will not give we're going to disobey the order of Lieutenant General Mbombo. The shootings at scene 1 changed that, because once there were shootings at scene 1, as operational commander and de facto operational commander, they were then in a position where they could take a decision, sorry, not operational, overall commander and JOCCOM commander. They could take a decision to stop the operation, and indeed should have taken a decision to stop the operation.
From a practical point of view, the provincial commissioner was present. I mean, there's some suggestion that she was outside in the passage, but I'm not sure how seriously one has to take that. But she was certainly around. So if they wanted to stop the operation, they could have either called her in from the passage outside or spoken to her if she was still in the passage and said, look here, things got seriously wrong. We've obviously got to stop. And I take it one must say, in all fairness, the probability is, regard being had to her experience being financial and they being the people with operational experience, she would have accepted the advice and said certainly.
Well, that would be our submission. I mean, certainly on the Monday, her instruction to Major General Mpembe was, once it was reported to her that deaths had taken place, she said, well, we must now stop the operation. It's not clear to me why she didn't act in that way on the Thursday. But our submission on scene 2 is that there would then be culpability in relation to Major General Annandale, Major General Mpembe, Lieutenant General Mbombo, Brigadier Karlitz, who was the operational commander in the field and who could have stopped the operation and should have. And we submit Major General Naidu, because he took himself into a position of de facto command at scene 2. And there is a passage in our heads where we deal with the ballistics evidence in relation to the victims in the killing zone, the victims whose deaths SAPS cannot explain. And without exception, the ballistics evidence suggests that those people were killed either by the K9 members whom Major General Naidu brought in unsolicited, or by the NIU members who he took over the rocks. Now, on either situation, he was in a position of command and control in relation to those members. And he was essentially witnessing a completely uncontrolled firefight, or shooting free-for-all. To call it a firefight suggests that there were bullets being fired back at the SAPS, which is not at all clear. a shooting free-for-all at the Kopi, which he did not bring under control and which it was incumbent upon him to bring under control. So our submission very strongly is that he must be held responsible for those deaths too.
What charge are we to suggest the provincial DPP should consider?
Well, it's difficult to... We don't know the evidence. But if there was a deliberate turning of a blind eye to a shooting free-for-all, a deliberate turning of a blind eye to a shooting free-for-all at scene 2, then the charge in relation to Brigadier Karlitz and Major General Naidu is a charge of murder, because there is a deliberate omission to stop a potential loss of life. But that's only if it can be shown that there is a deliberate turning of a blind eye. In our submission, it is quite possible that there was a deliberate turning of a blind eye. And certainly some of the evidence that has been given denying knowledge of the shooting, for instance, would be consistent with that. But at the very least, the charge to be investigated would be one of culpable homicide.
Point there, it would apply also to Kidd, I suppose, would be the failure to alert Brigadier Karlitz to the fact that they were there, that they were taking part in this operation, shall we call it. Karlitz didn't know that Naidu was there with people who were shooting. He also didn't know the Kidd was there with people who were shooting. Is that correct? If that information had been communicated to him, other things might have happened. Things might have turned out differently. Is that correct?
I mean, it was certainly, well, a breach of duty and a wholly inappropriate thing to have done, to have come in without invitation and without notice. But whether one can say that absence, that if Brigadier Karlitz had been notified, things would have turned out differently, I'm not sure that the evidence suggests that it would. One is speculating. But, Chair, there is one last topic that I did want to address, which is canvassed in our heads.
Topic, and I don't want to take much of your time, but it seems to me it may well be an important point. And that is, Brigadier Karlitz didn't give the people on the Kopi a warning. I'm inclined to the view that he may well have been obliged to under Section 9 of the Regulation of Gatherings Act. He was engaged in what amounted to a dispersal operation, and he should, prima facie, subject to argument we get from others, have given a warning. But it certainly, if he'd given a warning, it may well be that and given those on the Kopi an opportunity to respond to the warning, and people might well have all left the Kopi peacefully. Warning seems to me to be, prima facie, an important factor. I don't think you address that in your argument.
Or scene 2, Chair.
Scene 2.
At scene 2, yes. Well, it's part of a broader failure to exercise control as a POPs commander at the scene. Because the other extraordinary feature of scene 2 is that you have people who are holed up inside rocks and bushes where it's very difficult to engage them one-to-one, and no tear gas is used. It does seem quite extraordinary that if out of this entrenched position, using non-lethal methods and not having to resort to shooting at them, that nobody uses tear gas. And no... things may well have turned out different if Brigadier Karlitz had taken control, given a warning, used tear gas, given a place for people to disperse so that much, much higher. So there are many, many failings in relation to the Scene 2 operation. But we see the primary failing in relation to Scene 2 as the failure to exercise control to stop the uncontrolled shooting. 95 bullets shot into this kopje over a period of, 5, 6, 7 minutes, and nobody in a position of authority in SAPS brings that under control. The only people who try are Colonel Gaffley and Warrant Officer Mamabolo. And when they do try it, they are ignored. Chair, the last topic that I would like to address is a topic which has to be addressed, and it's a very, this whole commission has involved having to deal with really awful topics, but this is not about substance. This is about unacceptable conduct in the process or in relation to the process. And it's the topic that we address from page 625, which is under the heading, The Unacceptable Nature of the SAPS Response to the Shootings in the Commission. And is a matter for considerable concern, because what we have seen on the part is that this is a criticism of SAPS. It's not a criticism of our colleagues who have represented SAPS with extraordinary ability and dignity and professional integrity. I really do want to emphasize that. And to have, as I said at the outset of these submissions, performed an extraordinary job in normalizing what their clients did. But there is, what we've seen on the part of SAPS itself as an institution has been a complete lack of any self-criticism, coupled with an absolute lack of candor. And so it's canvassed in our heads, but from the very top down, untruthful evidence on very material issues has been given by all of the leading SAPS witnesses, all of the senior SAPS witnesses. And that's a process that seems to have begun almost immediately after the killings. So one sees the press statement that's issued the next day as having been tweaked from the report to the minister so as to sort of fudge the issue of Scene 2. In the bail application.
Just to create the impression that what was seen on television, the police firing at a group of people apparently charging at them, that was, the impression created was that explained all the killings and did not happen only at the end of Scene 1.
Indeed. I must emphasize there that while that was the case in relation to the press conference, its press statement, the presentation that Colonel Scott gave on the 17th made absolutely clear that there were two. So it wasn't a consistent position within SAPS, and Colonel Scott did make clear that there had been a Scene 2, and if the media had been a little bit more alert, the press statement wouldn't have got the currency that it did get, because those who he says, we saw it all on CCTV, we saw the shootings, this is how it happened. That's an exhibit that Triple Z5 now. There is some very important real evidence that was originally withheld or not disclosed by SAPS. The minute of the extraordinary NMF session. The original...
Never mind the minute, the fact that it happened.
Indeed.
The fact that it made the decision.
Indeed. The original notes taken in the JOC. The audio recording of the Provincial Commissioner at her meeting with Lonman. The early versions of the reverse-engineered plans for 13 to 16 August, which threw better light on what the true plans were. The video footage of the Provincial Commissioner's press conference on the 16th. Other evidence that cast SAPS in a bad light had to be discovered by the evidence leaders. It wasn't disclosed by SAPS itself. The ordering of mortuary vehicles on the 16th of August. The requisitioning of 4,000 R5 rounds on the 16th of August. The facts of the task team investigation. The various videos that SAPS attempted to conceal from the Commission and which are addressed in the heads of argument. The evidence relating to the planting of weapons on bodies at scene 2. And all of this points to a practice of not being candid with the Commission and of deliberately attempting to suppress the disclosure of evidence that may be embarrassing to SAPS. And that practice is well illustrated by an annotated marginal note on the statement of Brigadier van Graan that suggests that a sentence pointing to the inability of SAPS to account for deaths at scene 2 should be deleted because, in the quotation of the SAPS member who put it there, it will raise questions. And this suppression of evidence appears to have been linked to a deliberate attempt to advance false versions before this Commission, and in some cases, actually to fabricate real evidence to support those versions. We've dealt with it in the heads, but I do want to repeat it in these submissions. And if one looks at the SAPS case in relation to the 13th, the case is that its actions in engaging the strikers in the field were necessary because the strikers had suddenly changed direction towards the internal settlement, and SAPS needed to protect that settlement. It was a sudden change, was the version. Now, that version was manifestly false. The video evidence speaks for itself. And it must have been known by Major General Mpembe to be false, and it must have been known to be false by any SAPS member who was there on the 13th. Then there was the version that the SAPS plan that was ultimately implemented on the 16th with disastrous effects was actually a tactical plan that had been carefully worked out in consultation with POPs officers and had been in place since Tuesday the 14th of August. That too was manifestly false and must have been known by everyone to be false. There was a version that the decision to move to the tactical phase of the plan on 16th August was not predetermined, but was forced on SAPS because of the escalation of the risk of violence in the morning. That was manifestly false. It was known, the National Commissioner, Provincial Commissioner, Major General Annandale, Major General Mpembe must all have known it was false. And then there were the later versions that came out about the officers in the JOC and Brigadier Carlitz all being ignorant of the shootings in Scene 1 that also turned out to be manifestly false. There was the version in relation to incidents 1 and 2, which wasn't as transparently false as everything else, but must have been known at least by Brigadier Carlitz not to be the truth. And SAPS didn't content itself merely to advance false versions, it actually fabricated evidence to support them. So we see minutes of the 6 a.m. JOCCOM on 16 August, which were created at Roots in a form which avoided all evidence in the original notes which spoke of D-Day and that a decision had already been taken to move to the tactical phase, and instead put forward a false version that isn't there in the original notes, that there would be a move to stage 3 if there was escalation. That's what we see in TT4, original notes. We couldn't see it in the original notes because the original notes say it's D-Day. So from the original notes it was clear that there was going to be a stage 3 whether or not there was escalation. There were reverse-engineered copies of the plans of the week produced at Roots and later to support the version that the plan ultimately implemented on 16 August had been in place since Tuesday, and to obscure the fact that the tactical plan ultimately implemented was one that was thought up by Colonel Scott alone under pressure in the morning of the 16th of August. There was bullet damage on the Nyala Papa 5 that was there when it arrived at Marikana on the 15th that was presented as proof of damage sustained as a result of alleged shooting at incidents 1 and 2, which didn't happen. There were weapons planted on bodies of dead strikers, which we submit was nothing near as innocent as the process described as Warrant Officer Breert, but was rather an attempt to justify the killing of those persons. And I would in that context, refer you, Chairperson and Commissioners, to where we deal with the weapons planting in the heads, and in particular to Appendix 1, because Appendix 1 shows that the version that Warrant Officer Breert gave is not true. And all of those processes are related to a broader problem of closing ranks within SAPS in the face of criticism, and we've commented on this in the heads in relation to the address by the National Commissioner on the 17th of August. It's also reflected in the otherwise inexplicable failure of SAPS to investigate a range of actions of members or allegations against members which cry out for investigation. The failure of SAPS to investigate allegations of mutiny against Major General Mpembe on the 13th. Failure of SAPS to investigate the conflicting allegations in relation to the order to fire tear gas on the 13th. Failure of the SAPS to investigate any of its members in relation to reckless shooting on the 13th or the 16th. The failure of SAPS properly to investigate the allegations of Warrant Officer Myberg or the allegations of planting weapons on dead bodies on the 16th. If we could pick up that the version of Warrant Officer Breert was, one, incapable of explaining everything on its own terms, and two, transparently wrong on others, so could SAPS. And a corollary of this process of closing ranks has been a process of turning on anybody who breaks ranks. So when Colonel Vermaak threatened not to toe the SAPS line in the Commission, SAPS turned on him and seems to have encouraged a process by which allegations have been fabricated or appear to be fabricated against him. All of this is completely unacceptable, Chairperson, and all of this relates to the one punitive recommendation which we haven't addressed in oral submissions, which is a recommendation for proceedings to inquire in terms of Section 8.1 of the SAPS Act into the fitness of the National Commissioner to hold office. And we address that at page 1302 of our heads, and the basic submission is that the SAPS response to this Commission of Inquiry has been characterized by concerted attempts to mislead the Commission on several central issues.
Sorry to interrupt you, Mr. Justice. Am I correct in thinking that, certainly according to newspaper reports, there is an investigation on the go at the moment? Not I think, in relation to Marikana, but in relation to other allegations against the National Commissioner. Is that correct?
Chair, I'm just not aware of any such investigation, but if that doesn't mean it hasn't.
It's been widely reported in the newspapers.
What's been conveyed to me is that there are rumors, but nothing has been confirmed yet.
Anyway,
If there is such an investigation, we would recommend that that investigation be alerted to certain disquieting aspects of the SAPS.
One of the questions that occurs to me is whether that would be within our terms of reference to make such a recommendation. I'm not saying it isn't, I'm just asking, would it be?
There is a category of the terms of reference that deals with SAPS's response to the Chair. Let me find my note and argue this.
To suggest we take the tea adjournment at this point. Perhaps it would be suitable to do it, and then you can get your notes. And I also want to ask you a question I'd like to ask you now before we take the adjournment. And that is, there are statements on the SAPS hard drive which state attacks on the Nyalas and POPs. I think this relates more to incidents 1 and 2, or the alleged incidents 1 and 2, dealing with such things as trying to stab tires, throwing stones, and so forth, and also shooting. There's a number of statements in the SAPS hard drive which deal with these allegations, made by 5 constables and 2 lieutenants, and a lieutenant colonel. Now, they've not testified. Some of their names were on the list of witnesses whom SAPS wished to call, but were not called, perhaps because of time constraints. Now, the question I would ask you, and you can give me the answer after the tea adjournment if you're able to do so, is what are we to make of these allegations? But can we now take the tea adjournment and resume in strictly?
The NUM suggestion for a centralised
sentence.
Excuse me, don't broadcast.
Apparently blind to the
Shut up.
overwhelming maintain.
You just shift your folder across. There you are.
The Commission resumes. Mr.
Chair, to answer first in relation to the statements, I'm not sure which particular statements you're referring to, and I would like to consider them specifically to be able to address specific submissions on them. But the general approach that I would submit is the appropriate approach is that one cannot give any weight to a statement which says something that is clearly at odds with what a video shows. So one would have to see...
I'm going to put the proposition more broadly. If there's objective evidence, which clearly indicates that the correct position is A, the fact there's a witness who comes along and says B or Z, that is of no assistance. If the objective evidence is clear and unequivocal, that's the end of the matter for me. Yeah, okay.
So that would be the first inquiry. The second inquiry would have to be one to establish whether what the witnesses are describing is in truth that which happened in what SABC called incidents 1 and 2, or that which happened on the east side of the kraal in what SABC calls incident 3. Because it's quite clear that there were attacks on some nyalas on the east side of the kraal. We've referred in our heads to the statements from the occupants of Pape 11, which are consistent and which appear to be corroborated by a range of other statements, and which come from individuals who have gone out on a limb to make statements which are not towing the line, as it were. So it's one does need to... The submission from the evidence leaders is not that the strikers made no attacks on SABC vehicles. It's just that what was described as Incident 1 and Incident 2 did not take place. That the attacks that did take place took place on the east side of the kraal after the strikers had come round the point at which come round from the west side of the kraal. And it is an important distinction, because where we saw the version of Incidents 1 and 2 emanating is it was part of a version that SABC had exhausted reasonable POPs methods before it resorted to no avail, and then was finally left only with the TRT. And that, we submit, is a version that is incorrect. And that can be shown by the videos in that water and stun grenades and tear gas were not used before the strikers came.
These attacks on the vehicles on the eastern side of the kraal, that would be in the channel, I take it, near the channel. Those took place prior to the volley.
Yes, that would appear to be the case.
So that would be consistent then with the intention on the part, at least, of some of the strikers to attack the police.
At least to attack police vehicles, yes.
And of course, part of the plan had always been to have the TRT in place behind the POP members if it became necessary for the POP members to be protected by the TRT. If the POP members came under attack, then, according to the plan, they were going to take refuge in the Indialas if they could, but in any event, the TRT would take over and do what was necessary.
Yes, that was what the plan had in mind.
Which means, of course, that having regard to what is said in that done, that Colonel Scott moved forward to do what they had to do, and they came under attack. That was a possibility which he foresaw could happen, and he devised a remedy to deal with that, namely TRT behind with R5s, who could deal with it in the only way you can deal with a problem when you're armed with an R5. That's correct, isn't it?
That we identify as one of the problems with the plan, that as soon as POPs retreat, one is left with what is effectively a firing squad. Chair, the last issue related to the terms of reference, and we would submit that that having regard to clause 1.2.3, read with the introductory passage of the terms of reference, a recommendation under the SAPS Act would fall within your terms of reference. And in this regard, we start with the introductory passage. The Commission's appointed to investigate matters of public, national, and international concern arising out of the events at the area commonly known as Marikana mine, which led to the deaths. And in particular, report and make recommendations concerning the following: the conduct of SAPS, and 1.2.3, to examine the role played by SAPS through its respective units individually and collectively in dealing with this incident. And we would submit that that's broad enough to encompass how SAPS as an institution responded to this incident, which is really what our complaint is. And those are my submissions, not ours.
Thank you. Mr. Balinda, are you going to now conclude on behalf of the
Yes,
LNP?
Chair, I was going to be longer, but I'm going to try to do this in 15 minutes because there are other people awaiting their turn. There are only two matters which I'm going to address. One is the question of political interference, and then I'm going to say something very briefly about the National Management Forum. As far as political interference is concerned, which is fully addressed in our heads of argument, it seems to me that our written submissions on this issue may in fact have been misunderstood by some, and they were perhaps not sufficiently clear in their analysis. So I want to say what our position is. I want to start with two propositions. The first proposition is that the SAPS acted for improper political reasons in deciding to remove the strikers from the Kopi. And the second proposition is that the SAPS decision makers felt under political pressure when they made that decision. The improper political purpose is most clearly proved by the Provincial Commissioner's meeting with Lonman on the 14th of August. She herself identified the following political motives for the position which she took. Firstly, she identified a desire to support the NUM against AMCU. She urged management not to do anything which would lend any strength to AMCU or which would undermine the NUM. And I have to say that makes it very odd that the SAPS should now criticize Lonman for not negotiating with the strikers, when in fact the Provincial Commissioner said to them very clearly that they shouldn't, that they should dismiss them, and that they shouldn't lend any succor to the strikers or to AMCU, which they identified with the strikers. But in any event, she had the political motive of a desire to support the NUM against AMCU. She had the political motive of a desire to avoid giving Mr. Malema the opportunity to gain political credibility if he defused the situation. She had the political motive of a desire to keep other opposition politicians out of the picture. And perhaps most significantly, certainly for present purposes, she had the political motive of a desire to respond to the political pressure which she felt, emanating in particular from Khoza's phone call to the Minister. And it's important to recognize that the Provincial Commissioner was not alone in this. In what she says on the 14th, she clearly identifies that the National Commissioner has expressed these views as well, at least in relation to Mr. Ramaphosa and the NUM and AMCU. And there was no attempt to suggest that that wasn't the case. And we say that the fundamental flaw in the police case is that they've really failed to explain to this day, even in their heads of argument, why the decision was made to move in on the Kopi on the 16th of August. At first, the explanation was that it was because matters escalated on the 16th, but that was abandoned in the face of the evidence which emerged belatedly, which had initially been concealed, that in fact the decision was taken on the 15th. And so what remains is an explanation is that political factors, which I've listed, carried a great deal of weight. And it's reasonable to assume, given all of the evidence as to what the motive was, that it was political factors which triggered the decision on the 15th to move in on the 16th. No other explanation is available. None has been offered. Literally none. We know that the consequence of the decision was that 34 people were killed the following day on the 16th of August. And so the question which now arises is the following. If one accepts that Mr. Ramaphosa's call was one of the material factors in that political consideration, and we do accept that, the question is then, is he legally or morally responsible for the consequence of the decision to move in on the 16th of August? And to answer that, we say you have to answer two questions. Firstly, you have to ask yourself, is there evidence that the killing of strikers was a result which he intended or desired, whether that was actually his motive? And if there's no direct intention, then secondly, is there evidence that this is the result which he should reasonably have anticipated, so that he's in any event culpable on that basis? And Mr. Ramaphosa's evidence was the following. It was that Lonmin employees had been murdered by some of the strikers. He had been approached by mine management to intervene, to attempt to get the police to take action. He said that the action that he had in mind was that those responsible for murders and violence should be arrested. And there's no evidence that shows that what he actually wanted strikers to be killed, and there's no evidence which leads to the inference that that's actually what he wanted. His evidence in that regard, we submit, can't be rejected. He was a director of the company, and the management of the company was urging him to use his influence to attempt to persuade the police to act, and he did that. There's no evidence that what he actually wanted was that the police should kill some of the strikers. The only direct evidence actually negatives this conclusion. The direct evidence shows that he intended to meet the NUM leadership on the 17th of August, the day after the terrible events, to talk about how the conflict could be resolved. That contradicts a contention that he actually intended, or for that matter foresaw, what happened on the 16th. So the question becomes then, should he reasonably have foreseen this outcome? And that was put to him in cross-examination, and he denied it. There were no facts put to him which could reasonably lead one to the conclusion that he actually foresaw this outcome, that he foresaw that calling on the police to act to deal with the situation would lead to the police killing strikers, whether 34 or another number, or that he should have foreseen it. His evidence can't be gainsaid that what he had in mind was that they should arrest either the people responsible and contain the situation, and that a substantial police presence was necessary for that purpose. And one can't conclude from that he should have foreseen that this was going to happen. If we ask ourselves whether anyone else foresaw it, one may conclude that some of the police foresaw it, because mortuary vehicles were ordered. And we know what Major General Mpembe said about the consequences of confronting the strikers on the Kopi. So some of the police may have anticipated it. But I don't recall seeing, and there's no suggestion that there was any statement by anyone in the media or anywhere else that this is going to lead, the presence of the police is going to lead to bloodshed, and what's more, massive bloodshed at the hands of the police. I don't think anyone actually could have foreseen that, except perhaps some insiders. So we... Yes, Mr. Chastelson rightly points out that in the interview with the provincial commissioner on the morning of the 16th, when she says today's the day, the interviewer actually says to her, people are saying, why have you delayed so long for doing something about this? Why are you sitting on your hands? And so there's no suggestion that there was a public awareness that the police might kill people either in these numbers or in smaller numbers. So we say that the conclusions one must draw in respect of political interference are the following. Firstly, that the SAPS acted for improper political motives in deciding to clear the Kopi on the 16th. Secondly, that one of those motives was a desire to respond to the call which Mr. Ramaphosa had made to the Minister of Police. Thirdly, in that sense, the call which Mr. Ramaphosa made to the police was a trigger for what followed on the 16th, although it was a few days earlier. Fourthly, there is no evidence that Mr. Ramaphosa intended that the police should undertake an operation which resulted in the deaths of strikers. The evidence is to the contrary. And fifthly, that there's no evidence that Mr. Ramaphosa should reasonably have anticipated that the consequence of his call to the Minister on the 12th of August would be that the police would undertake an operation which would result in the deaths of strikers. That's to clarify what our position and submissions are. There's a question of fact and factual causation, and then there's a question of intention or what should have been anticipated. Then the only other matter I want to address briefly is the question of what the NMF knew at its meeting on the evening of the 15th of August. As we know, according to the minutes, this was a meeting which took place, a meeting of what the SAPS itself, not the parties, not the evidence leaders, not anyone else, what the SAPS itself called an extraordinary session of the National Management Forum. And according to the minutes, the meeting endorsed what we said was the proposal of the Provincial Commissioner that the strikers be disarmed, and that minute was settled by the National Commissioner. And we know that it was only because that all of this only came to light through a piece of good luck. After it had been concealed consistently, a piece of good luck that the evidence leaders were informed by a third party of the meeting which had taken place. And the message we received was, call for a copy of the minutes and have a look at item 7. And that's what we did, and that's what produced the minutes. And that led to the evidence. Now, the question is, what was known to the meeting? We submit that it's clear from the evidence, although it took some time for it to emerge, that the assembled generals must have been told what the plan was. They could hardly have endorsed a proposal without knowing what it was. And after some evasion, the National Commissioner agreed that this was in fact the case. And can I just give the commissioners the page references to where she agrees that? It's page 37413, line 17, to page 37414, line 5, and then again page 37417, line 19, to page 37418, line 6. That's where the National Commissioner says the plan, the members were told what the plan was. She said she couldn't remember what the plan was, but she said they were told. She said to remember that was a fine point of detail. I can't remember the word she used.
Talked about a pedantic detail.
About?
Pedantic detail.
She said it was somewhat pedantic to be concerned about what they were told. The chairperson then addressed interrogatories to the people who had attended the meeting and who had not given evidence to ask what they'd been told and what happened at the meeting. And I've handed up to the commissioners, and the parties have a series of the emails which have passed so far in that regard. There have been responses now from 8 generals. There are 2 things to be said about those responses. The first thing to be said is that, to put it very politely, most of them have refused to answer the questions which the chairperson asked. The chairperson asked 9 very specific questions. Most of them have not answered those questions. That's a matter for very great concern, that there's simply no answer from most of them to the questions which are asked by the Commission of Inquiry. But there is one answer which is helpful. One person finds it in himself to give some information, and it is I think it's himself, I'm not sure whether it's himself or herself. It's from Lieutenant General Basson, the Northern Cape Provincial Commissioner, and it's on page 10 of that bundle which I've handed out. Can we get an evidence? Quadruple Z35, that bundle will be. The page 10 of quadruple Z35 says, Lieutenant General Mbombo informed the meeting that there had been a prolonged strike action at Marikana during which people lost their lives. They had received information from crime intelligence, which indicated that striking employees congregated at Marikana were armed. In order to prevent further loss of life, she indicated that an operation was planned to be executed on 16 August 2012. General Pierre asked Major General Ngobo whether the intelligence gathered had been confirmed. Lieutenant General Ngobo confirmed that intelligence was gathered that striking mine workers were armed. Now we know in fact what the intelligence was. The intelligence wasn't just that they were armed, it was that they were armed and that they would resist with force any attempt to disarm them. And that's common cause. So we know that in fact what has finally emerged is that from that document is that the NMF was told what the intelligence was, and we know what the intelligence was. And then we also have the statement of the National Commissioner also finally extracted from her with some difficulty, and the page reference is page 34718, line 20, to page 34719, line 6, where she says they were told what the intelligence was.
Sorry, Mr. Badru, just remind me, Major General Mtobo, what is that a he or she? What rank does he or she hold?
Major General.
Major General Mtobo, answer to the interrogatories, his own answer, is at page 2.
Page 2.
But what is here on page 10? General Fiega asked Major General Mtobo.
Yes.
So it's not Major General Mbombo.
No.
It's not Lieutenant General Mbombo. No. It's Major General Mtobo. Now, what position did Major General Mtobo have?
I understand he was the head of crime intelligence.
Yes.
Yes.
So the question was asked by the National Commissioner of the head of criminal intelligence, who obviously would have been aware of the information that had been gathered.
Yes.
And the answer given, sorry, I was interrupting you, on page 10 is the one that you've read. Sorry. I just want to know who
yes. He's the head of intelligence. One can safely assume that he gave an accurate account of what the intelligence was. But we have, as I say, also the reference to what the National Commissioner has said. And so we have the situation that the assembled generals, not all of the generals, but the provincial commissioners and the top leadership of the SAPS endorsed the proposal that the operation be undertaken the following day to confront the strikers and remove them, disarm them. And they must have known of the risk that was involved, that there was a high risk of bloodshed. Mr. Chaskelson has dealt with the question of legal liability or causation. Clearly there was factual causation. If it hadn't been for that decision, the operation wouldn't have happened. If the National Management Forum extraordinary session had said, no, don't do this, this is too dangerous, let's think of something else, it wouldn't have happened. So there was factual causation. Whether there was legal causation depends on whether the chain was broken by new acts intervening, and we'll make submissions about that in writing in due course as to what the test is. Our current view is that the new acts which intervened were such that many of them could have followed a different cause and resulted in a different outcome, and that therefore it's not possible to find a prima facie case of murder or culpable homicide on the part of the generals. But we'll review that in the light of the question asked by the chair and make further submissions in writing on that in due course.
Now, I must say that one answer that concerns me, one of the questions that was asked was, in 7, did you raise the question of the risk of confrontation, injury or death if an attempt was made to disperse and disarm at the copy approximately 3,000 strikers, some of whom were armed with dangerous weapons? 8, did any other person raise the question of that risk? If so, who did so? If the question of risk was raised, what was the response by General Mbombo? What basis did the meeting decide to endorse? Now, the answers given by Lieutenant General Binter, the Provincial Commissioner, Eastern Cape, page 3. I must confess I found it rather strange. 7, I never made such a comment. In other words, I never raised the question of risk. Did anybody else raise the question of risk? I can't recall. If the question of risk was raised, what was response by General Mbombo? Can't recall. Now, it seems it stretches one's credulity rather far. I know we've had stretches of our credulity in this commission already, but it stretches our credulity rather far to think that a provincial commissioner can solemnly say, I was party to endorsing this proposal. I can't remember if the question of any risk of bloodshed and so on was raised, and I can't remember what the response was. That it may be, well, anyway, that's the answer. But I just thought I should mention that.
Chair, that is the answer, and it's simply not credible. One has to recall what we're talking about. This is a meeting taking place on the night of the 15th. While it was still fresh in their memories, the following day, 34 people were killed, and there was an international outcry. It's impossible that that didn't cement in the memory of those people who were present at the meeting what had happened the night before, what decision they would have made. Any rational person would have said, I wonder whether we should have anticipated this. Last night, we decided this operation should be undertaken. I now see that 34 people have been killed. I wonder whether we made the right decision. Any rational person, any responsible person would have thought back on the events and thought, did we anticipate the risk? And the fact that now no one, well, there's one person, Lieutenant General Besson says no one raised the question of the risk. All the others either duck the question or say they can't remember. It's simply not credible.
General Mawela, who is the Divisional Commissioner for Operational Response Services, I think was Major General Annandale's superior. His statement is page 4. And you saw the questionnaires that was sent. It's on page, the questionnaires on page 1 deals with the question of whether you recall anyone raised the question of risks and so forth. And his answer at the end, having not dealt with that, is to say that's all I can recall. So he's also saying, I can't recall whether anybody raised risk. He's the person who is responsible for operational response services. It's an extraordinary, prima facie, obviously.
If one analyses these statements, one is left to be absolutely blunt with a feeling of absolute despair. These are the most senior people in the South African Police Service. They're asked some very important questions by a commission which is investigating, as Mr. Chaskalson put it, the greatest catastrophe since we achieved democracy. The answers are evasive, are non-responsive. Let me just read you one more. I don't want to waste. It says, page 8. You ask these generals these specific 9 specific questions with 2 sub-questions, and this is what the Provincial Commissioner of KwaZulu-Natal, Lieutenant General Ngubeni, says. He says that he's a general, etc. He says, I wish to state on the 15th of September I was on duty attending an NFF meeting. During the same meeting...
I believe Lieutenant General Ngubeni is a lady.
A lady, she says. Lieutenant General Mbombo was present, and then she says the following. All she says about the meeting in response to your 9 questions is the following. The National Commissioner asked some of us to remain behind after the meeting. The National Commissioner then asked the Provincial Commissioner of Northwest Province, Lieutenant General Mbombo, to brief us on the prevailing protest and the support she might need. The briefing by Lieutenant General Mbombo was more about issues of Northwest, which has no bearing in KwaZulu-Natal. That is the answer to 9 questions asked by a commission of inquiry dealing with this catastrophe. I say with, and I choose my words not recklessly, it's a disgrace. I have no further submissions, Chair.
Mr. Butlander, I agree prima facie with the criticism of the provincial commissioners as to the failure to answer the question. I agree there with you. But I just want to check regard being had to the experience of the provincial commissioner with regard to the operational aspects of the public order policing, do you think that she would have been in a position to have what the plan is? And
Well, Commissioner, that is a fair question. I'd say the following in response. Firstly, the National Commissioner says, in her evidence, finally says that she did tell them what the plan was. Secondly, if she decided to implement that an operation was to be implemented the following day, the tactical stage, to remove the strikers from the Kopi and disarm them, if she made that decision without knowing what the plan was, then it's utterly reckless. Then it's truly utterly reckless. And I submit that one can accept readily that she didn't have the skills and the experience to judge whether the plan was a good one or a bad one. That's one of the criticisms we make. Part of the problem is at the top of the chain of command you have two people who had no experience. So she no doubt would not have been in any position to make an informed judgment on whether the plan was a good one or a bad one. But to find that she made a decision and issued an order that the tactical phase must proceed without knowing what the tactical phase was would really be to impute recklessness to her of a degree which I don't.
My next question is, provincial commissioners, I take it they would know that the people who are handling the situation were senior people, most experienced people. Don't you think they would have assumed that a proper plan would have been put in place to execute whatever action they wanted to?
I assume they would have hoped that a proper plan and maybe assumed that a proper plan was in place. But you can't endorse a decision without knowing what the consequences of a decision are or what the nature of the decision is. They would no doubt assume, perhaps somewhat optimistically in the light of experience, that it was a plan which was properly planned and would be implemented properly. But you can't, given that they knew that the strikers on the Kopi were armed, given that they knew that the strikers on the Kopi would resist with force if an attempt was made to disarm them, it would have been the recklessness then extends to the entire National Management Forum extraordinary session if they didn't say, but how are you going to do this without lives being lost? They're asked to endorse a proposal. A proposal is made, and they say, we endorse it. If they endorse it without saying, but how are you going to do this without lives being lost, then that is a criticism not of the Northwest Provincial Commissioner, not of the National Commissioner, of the entire top structure of the South African Police Service, that they endorsed a decision of this kind which was inherently dangerous and risky without even bothering to find out what it was about. That would be a truly shocking conclusion, Chair.
It goes further than that, because the police version, which the entities don't entirely agree with, but the police version is that this is an unprecedented situation, that by implication they never had 3,000 people on a Kopi with dangerous weapons who have to be disarmed. That being so, if it's an unprecedented situation, you would be particularly interested, I would have thought, in the plan that's being devised to deal with this unprecedented situation. And particularly where you have someone like General Mpembe, who thinks with his experience that there's no plan that you can come up with that would involve disarming these people on the Kopi without the serious risk of bloodshed.
Respect that is so, Chair. And we have the evidence of the National Commissioner. She says they were told what the plan was, and they were told about the intelligence. Then the first thing you ask is, well, how are you going to do this if you're a person of any responsibility at all? I truly don't want to intrude on other parties' time any further than I have, Chair, so unless there are questions, those are our submissions at this stage.
Thank you, Mr. Butler. Ms. Leroux?
Thank you, Chair. Chair, the eyes of the communities that were devastated in August 2012, as well as the country at large, and indeed the world, returned to watch the Commission complete its work. Mr. Chaskelson, when he began his address, echoed what is set out in Part 1 of the Human Rights Commission's Heads of Argument. But it bears repeating what is said out there following a day where we've been immersed in complex legal questions. After 2 years of Commission hearings, the shock of the catastrophe of 9-16 August 2012 may have dulled. 40,000 pages of transcript may have normalized the abnormal. Tens of thousands of pages of written evidence may have immunized against the horror of the killings. But we must not forget that the level of violence at Marikana and its tragic consequences were of a scale unprecedented in democratic South Africa, and the South African Human Rights Commission submits, these were events that constitute violations of the rights to life, dignity, freedom and security of the person. 34 fathers, sons and husbands were shot dead by the police in a single day. More than 50 others were seriously wounded by bullets fired by the same police service, yet not a single police officer has yet been disciplined or charged. Marikana sits alongside Sharpeville and Soweto, evoking domestic shame and international condemnation. The task of the Marikana Commission is to ensure accountability for these horrors, to make recommendations that prevent its recurrence, and to restore confidence in the state's ability to ensure justice. And it's to assist the Commission in this important task that the South African Human Rights Commission has participated in these processes.
Sorry, let me interrupt you. Why was the Human Rights Commission not involved during the incidents when people were dying there? Was it not incumbent also on the human rights to participate in trying to protect the lives of the people?
Commissioner
You do a
Chikota,
good job here, but don't you think we would have done a good job there as well?
Commissioner Chikota, all I can do is return to the evidence of the expert who we have provided to assist the Commission, Mr. Gary White, who stated that there are always third parties whose assistance would be welcome to avoid violent protest, public order policing operations going wrong, and to assist the police in their job. But the reason why the Human Rights Commission is here today is because it seeks to assist the Commission through the provision of that expert evidence.
No, that's not my question. My question is, why were you not involved there? Let's answer that question, that's all. Questioning your participation here at all. Don't get me wrong.
I understand that, Commissioner Chikota, and perhaps in hindsight, my client would need to look at whether in those types of situations it could play a different role. I don't have an answer for you as to why it wasn't there at that time.
I'll ask you a question. Has the Human Rights Commission ever previously participated in standoff kind of situation where it was anticipated that there might be breaches of human rights? Has the Commission ever intervened, endeavouring to facilitate a settlement, endeavouring to prevent breaches of the kind that have arisen? Or would, if they had intervened here before the 16th of August and endeavoured to provide some kind of facilitation or mediation, would that have been a first as far as they were concerned?
Chair, as far as I'm aware, it would have been a first. The Human Rights Commission's mandate is obviously determined by legislation that governs it as well as its constitutional mandate, which generally is responsive once it receives complaints. And that is indeed why it participated in these processes. It received a complaint about the conduct of the National Commissioner with respect to the shootings at Marikana. So I would have to take instructions on whether proactively it has intervened in these type of situations. It generally would follow the legislation that governs it and its constitutional mandate, which is generally reactive, and in this instance was in response to a complaint about the National Commissioner. But Chair, that does mean that the parameters of the Human Rights Commission's participation have focused primarily on the police operation and constituted primarily the assistance of expert evidence, Mr. Gary White, the public order policing expert from Northern Ireland, Mr. Degan, who undertook the video compilation by the Human Rights, which was provided by the Human Rights Commission together with the families, and Catherine Scott, who did the audio analysis of the Reuters footage and others. But Chair, in summary, the approach that we've taken in our submissions as well as in the participation in the 2 years of the Commission proceedings have been to focus on the objective evidence, to be guided by the experts. We've situated this all within a human rights framework and seek to give effect to the state's international and domestic law obligations, which it seeks to satisfy through the instrument of this commission. The constitutional scheme that we speak of has accountability and transparency at its core. And there are two things in particular that inform this human rights-based approach. And I'll get to these in more detail tomorrow. But to highlight, the first of these is what's known as the principle of prevention and precaution. This is that measures must be taken to prevent or minimize the risk of the need to use lethal force in the planning and command of a policing operation where the use of such force is anticipated. And Chair, I must just make a preliminary point with respect to the principle of prevention precaution, which is that we've been very careful not to refer to it as the McCann principle, because McCann is a case of the European Court which applies that principle. But this is a principle that is applicable to the events at Marikana because it is a principle of human rights law, it is a principle of international law, and it has been domesticated into South African law through the constitutional obligations of the state to give effect to its international law obligations, but more importantly, to give effect to its obligations to protect the right to life. That is where the principle arises from. So the SABC can be held liable for its conduct at Marikana by the application of the principle of prevention and precaution on a standalone basis. This is separate and distinct from whether any criminal or civil liability should flow. The principle arises because there was a breach of the right to life by the South African state through its agents, the South African Police Service. And therefore, the principle of prevention precaution does not come into play when we're trying to determine questions of criminal liability. It is a principle that holds the organization accountable because of the failures of the operation. Those have been enunciated repeatedly throughout our heads, but it's for those organizational failures to plan and command to implement this operation in an effective and appropriate and professional way that there was a breach of the right to life, and therefore that the principle of prevention and precaution provides the basis for this commission to hold the SABC accountable as an organization. The second duty that informs the human rights-based approach that has been pursued by the Human Rights Commission here is the duty to investigate that arises when the right to life has been breached by the state. And Chair, I'll address you tomorrow with respect to what the consequences of that duty are. But what it essentially amounts to is ensuring accountability. And there are at least 5 ways in which accountability is served through this commission discharging the duty to investigate. The first is that this commission will make an accounting to the President and to the country at large as to what happened. That accounting will also be obviously most important to the victims most affected by those events. Secondly, there's the accountability of the SAPs to this commission. And as we've set out in our submissions, as well as echoing the evidence leaders, the SAPs in this process has unfortunately been characterized by a deficient, deliberate, and deplorable failure to engage with this commission process, and that therefore has consequences for how evidence can be treated. Thirdly, there's the accountability of the SAPs to the victims. And Chair, it's obviously for yourselves, for the National Prosecuting Authority, and for IPID to determine what that would mean in terms of any potential criminal liability. And my client certainly has not made explicit recommendations for prosecution, deferring to your own mandate as well as those of those other 2 institutions who are charged with determining criminal liability. But we certainly in our recommendations have urged that compensation be provided so that further litigation is avoided. Fourthly, there needs to be accountability within the SAPs. In that respect, the recommendations by Mr. White, which are echoed by both of the other policing experts that testified, seek to address training, seek to have a review of policy and standing orders, seek to suggest various mechanisms that are very practical, that if implemented would ensure that future operations could avoid the failures that we see here with respect to intelligence planning, briefing, command and control, and ultimately accountability where there are such failures. And finally, it is accountability that is at the heart of all the recommendations that we have submitted, both those arising and set out in Annexure A, which are the recommendations proposed by the Commissioners of the South African Human Rights, and secondly in Annexure B, the recommendations by Mr. White. But Chair, in much of the engagement with the evidence leaders' submissions was that there's possibly an understandable desire to make findings against or about conduct, decisions, and steps taken by individual officers. And the evidence before the Commission may or may not assist in reach those conclusions. But what the evidence does show is that the SABC, as an organization, should and can be held accountable for those failures. It is its processes that failed. Mr. White identified how they failed with respect to intelligence planning, briefing, command and control, and accountability mechanisms. And it is those failures that resulted in the deaths and injuries at the hands of the state that constitute the breach of the right to life. Chair, we've also obviously explained in our heads of argument at Part 15, Section 4, that there is a mechanism for the SABC to be held accountable, potentially through the Occupational Health and Safety Act. But the key here is that it's not necessary for the Commission to find individuals liable. There's sufficient evidence to hold the SABC liable for what happened in August. And Chair, the second component of that is that obviously, because this is not a criminal trial, and it's not even a civil trial, the same types of nuances and standards do not need to be met. And I'll address you on that in more detail tomorrow when I deal with the duty to investigate. So, Chair, in the 3 minutes I have remaining today, because I'm assuming we finish at 4 o'clock, to briefly explain the structure of my oral argument, it's to focus primarily on parts 2, 4, 9, and 10 of the heads of argument, as well as the two annexures I've mentioned that deal with recommendations. I do not intend to address the detailed, fully referenced, factual account that is set out in the submissions, unless there are particular factual questions that you and your fellow commissioners would like me to address you on, in which case I'd like to prepare for that overnight. So if I could be alerted to any particular factual issues set out in our accounts that you would like us to address. Chair, I also don't intend to spend very much time at all on our Phase 2 submissions, save to state that the South African Human Rights Commission is disappointed that the underlying causes of the tragedy of August 2012 did not receive anything close to the same attention as those that the immediate causes received. And we therefore urge the Commission to adopt the proposed recommendations to remedy that lamentable failure. Briefly, Chair, those were four recommendations proposed by the Human Rights Commission, that the important work to understand these underlying socio-economic causes continue through a task team or a working group that would involve government, communities, mining rights holders, trade unions, traditional leaders, employees, and local business. That the Department of Mineral Resources would undertake a review of the SLP system. That Lonmin's compliance be specifically investigated with respect to the SLP system. And finally, that funds be allocated to develop the infrastructure of the communities of Marikana. And we note in this regard that Lonmin in its reply expressly supported those recommendations. Chair, I note it's 4 o'clock, so I'll continue in the morning.
Thank you. If there's nothing specific that we'd want to put to you now, we will resume the sitting of the Commission at 9 o'clock tomorrow morning.